Okay. Good morning, Honorable Minister of Justice, the Honorable Justice Barishaki Cheborian, Judge of the Appellate Division, East African Court of Justice, the Director of Programs, Cepil, and the Chief Technical Officer, Cepil, our trainees today. I wish to welcome you today to the training of legal professionals of Uganda on good governance and rule of law in the East African community. My name is Christine Mutimura, and I'm the Deputy Registrar of the East African Court of Justice. So before we start, I would like to kindly request our guest of honor, the Honorable Minister, the Judge from the East African Court of Justice, and the Director of Programs to please come and take your seats at the front. Karibuni. Honorable Minister and the Honorable Judge, the trainees present, once again, I would like to welcome you to today's training of legal professionals of Uganda on good governance and the rule of law in the East African community. Honorable Minister, this is the fourth training that we have undertaken in the region so far. And this training was a brainchild of Cepil in Uganda, who have for a long time partnered with the East African Court of Justice to ensure that not only our judges, but also legal professionals from the region are trained on good governance and the rule of law. In this training, trainees have also had the opportunity to be trained on the EAC as a community, what the legal framework is, our principles, as well as the different organs and institutions in the community, so they have a good understanding of what the community is, what it entails, and exactly what its purpose is as a vehicle of regional integration. The trainees are also going to have an opportunity to be trained on the EACJ's functioning, its mandate, as well as the jurisprudence. And we want to thank Ford Foundation, who are the sponsors of this training, for being able to facilitate our training so that we are able to train the advocates. Honorable Minister, as you'd understand, it is the advocates who make the greatest contribution to the development of jurisprudence in our courts. And we have not taken that for granted in the region, and we understand their key role as a stakeholder of our court for purposes of fast-tracking integration. So without wasting time, and before I invite you, this is a training that is going to take 2 days, today and tomorrow. The trainees are going to be able to interact with cases that have been decided by the court, but also be able to undertake practical exercises to inform them on how to file matters before our court. I would like to therefore now invite Mr. Francis Gimara, the Director of Programs, to make his remarks. Thank you.
The Honorable Minister of Justice and Constitutional Affairs, Honorable Norbert Mao, the Honorable Justice Barishaki Cheborion, who is Justice of the East African Court of Justice Appellate Division, but representing the President of Cepil-Eacj, Her Worship the Deputy Registrar, Christine Mutimura, and all you land friends, advocates, and indeed invited guests. I want to, on behalf of the Center for Public Interest Law, which is a CSO organization registered in Uganda, but whose core mandate is to promote public interest using law as a tool, has for some time been evolving ways in which to share some of the knowledge across spaces that promote public interest. It is in that regard that we have been undertaking, with partnership of the East African Court of Justice, together with the Ford Foundation, we have been undertaking trainings on the two twin concepts of good governance and rule of law as understood or articulated by the East African Court of Justice. The trainings have been under a theme. The theme has been strengthening civic space, good governance, and rule of law in East Africa through the Cepil-Eacj legal architecture. Why is this important? The 2 days training certainly will demonstrate on why this undertaking is very important. But our guests of honor want to inform you that this is the second phase of the training. The first phase, we train the judges across the East African countries. And as a result of training of the judges, the recommendation then was, why should you train the judges without the advocates? As you all know, the saying that a good bench is dependent on a good bar. A good bar is equally dependent on a good bench, isn't it? So on the basis of that, we thought that the training should be extended to advocates. So we have completed the first training of the advocates in Dar es Salaam, in Kigali, and Nairobi. This is the fourth EAC partner state where we are undertaking the training. The trainees are going to have 2 days of a very practical exposition on the legal architecture of the EAC law. But importantly, we will be sharing the training from two resource materials. Cepil has prepared 2 authoritative pieces that have been put up by a team that has been led by Dr. Noria, who will be the lead trainer in these 2 days. But it's a very authoritative publication on the source book on good governance and rule of law in East Africa. You will find in that source book, trainees, that we have compiled all the authorities on what good governance and rule of law means as far as the Cepil-Eacj jurisprudence is concerned. We have also compiled a litigator's manual, because I remember many years ago when we first litigated before the Ecj. We groped in the dark. Even then the procedures were not very, very clear. The court was struggling to understand procedure. They were in fact evolving the procedural rules. One instance, when we did a statement of claim, the earlier litigants before the court, the rules did not provide that you attach an affidavit. So we had to always debate between Professor Cepil-Eacj and the Osongos in Kenya. How do we introduce evidence before the East African Court of Justice? The court was learning, the advocates were learning. But over time, the rules have now been refreshed. We have a new set of rules. Over time, the jurisprudence has clarified that you need evidence to place before the court regarding your claim. So both the source book and the litigator's manual are two documents that you will only need if you are to ever file a matter before the Ecj. A lot of time and effort has been expended on this. And I'd like to ask you to join me in clapping the team at Cepil, led by Dr. Noria, in expending countless hours to get these two documents. So the question is, why the training? Integration law, where integration has worked, has largely been promoted through litigation. So the quality of the bar and the understanding of the bar about integration law is very, very critical. One thing that we have not seen, which is very, very important, which we will explore in the training, is how do you use the preliminary mechanism in the treaty to grow EAC law? How do you litigate EAC law before the national courts? It's going to be something that we must all leave this room when we know. Why? Because the East African Court of Justice has brilliantly, like never before on the African continent, exposed what good governance and the rule of law means in their judgments. And you will see this through the course of the day. So we hope that if we understand how the court has interpreted these twin concepts, then it's going to be very easy for us as lawyers to directly litigate these matters before these courts without even flying to Arusha. We want to invite the trainees to understand that you can begin to litigate based on only the EAC treaty because it is an act of parliament in Uganda. So how do you plead a cause of action the way we know it, but in addition to that, plead that whatever has been done is also a violation of the treaty and the protocols. That is going to be possible with this training. We hope to see that you will be contributing jurisprudence that will evolve regional law, because it is possible today through the preliminary mechanism to create a precedent that will bind all the partner states. And we want to do that because the court has already set out a path. The court has, even without a human rights jurisdiction, expressly conferred to it, innovatively, in Sitenda Sevalu and others and several authorities, laid out a clear path of what good governance and rule of law is. The court has also said, in certain matters, we have concurrent jurisdiction, but preferably start at the domestic level. That was the advice of the court in Alcon International versus Standard Chartered Bank. So we see that these circumstances require us as advocates to be empowered. And we are here to learn. It will be 2 days of excitement. And this morning, we will be having the Justice Cheborion share remarks from the court together with the minister, and they will participate in launching these 2 books, and then we will have the training started. Now, we will share these copies of these books via, we'll give them to you in flash disks because they have hyperlinks. So it's going to be possible that you no longer have to walk to the library to do any research on EAC law. If you get the document with hyperlinks, you will read the summary and then click the hyperlink and you'll get the full decision. We hope that at Cepil, when we do that, we will have contributed to promotion of good governance and rule of law. What we expect from you, to be attentive, but most importantly, to leave this training as those who are going to use to help your clients advance the rule of law and good governance using the EAC legal framework. I thank you so much, and I want to invite you to clap for yourselves because you are selected very carefully. The training, the demand was too much, but the resources could not permit, so it was a rigorous process of selection based on your expression of interest on how you would like to use the EAC law to practice and help your clients. So I welcome you on behalf of Cepil, and I wish you a fruitful 2 days of learning EAC law. And most importantly, I pray that you will use the knowledge to advance rule of law and good governance in East Africa. Thank you for listening to me.
Thank you very much, Mr. Gimara. Thank you for giving us a taster of what to expect during the training sessions. And I want to echo what you said and recognize the trainees that we have today and congratulate you, even though you've not yet concluded the training, for having made the cut during the rigorous shortlisting process to be able to qualify for this training. So without wasting time, I would like to invite the Honorable Justice Cepil-Eacj Eborian to make his remarks.
Thank you. The Honorable Norbert Mao, the Minister of Justice and Constitutional Affairs, whom we fondly refer to as Chairman Mao in many times, and who is a lawyer in his own right. I say so because previously, that position of Minister of Justice and Constitutional Affairs has been occupied by non-lawyers. But I think this time round, we are lucky that the position is occupied by a lawyer. Your Worship, Christine Mutimura, the Deputy Registrar of the East African Court of Justice, Mr. Francis Gimara, Senior Counsel and Director of Programs, Center for Public Interest Litigation. Francis Gimara is Senior Counsel. I hope many of you don't know that. To be a Senior Counsel in Uganda, it is not a democratic process that you are elected. It is through your performance as a president of the East African Court of Justice, at the Uganda Law Society. Dr. Henry Honoria, Chief Technical Advisor, Center for Public Interest Litigation. Trainees who are here, I'm told you were also selected through a competitive process. Thank you. Ladies and gentlemen, I am delighted to be here and make a few remarks at the launch of the training of legal professionals from Uganda on good governance and the rule of law in the East African community. I do this on behalf of the Judge President, Honorable Nesta Kanyobera, of the East African Court of Justice, who would have wished to be here but has not been able to attend due to other exigencies of work. Allow me to thank the Center for Strategic Planning for their initiative of ensuring that legal professionals in the East African community, partner states, are trained on good governance and the rule of law. The Center for Public Interest Litigation has, with the support of the Ford Foundation, partnered with the East African Court of Justice for these trainings to take place. I suppose that you know now that the community has 7 partner states, not so? Recently, the Democratic Republic of Congo joined. That is in addition to Burundi, Rwanda, Tanzania, South Sudan, Uganda, and Kenya. So we are now 7. As the East African Court of Justice, this training of legal professionals is very key in enhancing not just the functioning of our court, but also the development of the court's jurisprudence as well. As such, legal professionals who use our court are key stakeholders to the court. So we are training you to be able to contribute to the jurisprudence of the court. That is why this training is taking place. Speaking of the court, it was inaugurated in November 2001 and has, in its 20+ years of operation, had its jurisprudence greatly expanded. Thanks to the diligence of the legal professionals like you, NGOs, civil society, and cross-border commercial operators who have filed cases on a number of issues. We thank the NGOs and civil society because many times they come in as amicus curiae to the court to support in its work. The mandate of the court, as spelled out in Article 23 of the treaty, is to ensure the adherence to the law in interpretation, application, and compliance with the treaty. We have received a significant number of cases in the area of good governance and rule of law. We have also dealt with matters on trade, particularly those relating to the infringement of the provisions of the treaty for the establishment of the community and the East African Community Common Market and Customs Protocols. The details of the matters and the corresponding court decisions can be accessed by you online on the East African Court of Justice web portal and in the court's law reports. I suppose you now know that the court produces reports which are easily accessible, both online and in hard copies. Although there is no explicit provision in the treaty for the court to handle human rights matters, the court has interpreted Article 6, Article 7.2, Article 6.8.1c, 23 and 27.1 of the treaty in the case of Katabazi and East African Community and AG of Uganda in reference number 1 of 2007 to enable it handle human rights related matters. So you shouldn't worry that because it is not there, the court has found a way of making sure that this area is also handled by the court. Because you know all matters we do, actually everything relates to human rights. Whether it is property, whether it is business, it's right to this and right to that, including elections and politics and so on. The jurisdiction of the court also extends to arbitration and mediation. In February this year, the Appellant Division delivered its first 2 awards. This was a positive sign of the increased mandate of the court. The First Instance Division also successfully concluded 1 mediation matter in 2021. The court always encourages parties to proceed through court-annexed mediation before it can proceed with the hearing of a matter. It just operates the same way that we do here in Uganda. Try mediation, the court will encourage it, and then if it fails, you proceed to proper litigation. There will be an opportunity to share more on the jurisprudence of the court during this training session. As the Senior Counsel Gimara has said, the court has developed its own jurisprudence, and which is different even from the European Court of Justice. We've come up with our own jurisprudence on a number of matters, and this will be matter of interest to you, which you can even use as authorities and precedents in your work here in the national courts. Allow me to conclude my remarks by once again thanking Mr. Francis Gimara and Dr. Honoria, who have been very instrumental in ensuring that these trainings are conducted as planned, because they are moving from one country to another. They are moving through all the East African community states to train people of your caliber. I also thank you, dear participants, for taking time to come and participate in these vital sessions. I can assure you that you will not regret. I thank you.
Thank you very much, Honorable Justice Cheborian. And I would now like to invite our chief guest, the Honorable Minister Norbert Mao. Kindly, you're welcome to give your opening remarks and officially launch this training. Karibu.
My Lord, Justice Barishaki Cheborian, Francis Gimara, Senior Counsel, and the team of Cepil. I don't want to stand for too long between you and the rich menu awaiting you. I trust Cepil, and that's why I accepted to be here. In 2011, after losing a presidential election, I was offered a chair and a desk at the Center for Public Interest Law by my friend Francis Gimara, Senior Counsel. I didn't do much relating to the law, but I interacted with a number of eager young people who are willing to continue learning, but also assisting in developing jurisprudence. Cepil has been involved in a number of cases in many areas: human rights, customary land. Cepil also launched a publication on international trade. So I'm saying that so that you just don't think that Cepil looked for a guest of honor arbitrarily to come and make a speech as a formality. I'm not here as a matter of formality. I'm here because I believe in the mission and the vision of the Center for Public Interest Law. I congratulate those of you who have been selected to participate in this training. We believe that this will position you to excel in this unique area. International courts are not very popular with many countries. America is one of the countries that supports international courts to have jurisdiction over other people, but not over the United States of America. In my own simple way, I'll tell you that the treaty establishing the East African Community is the Constitution of East Africa. So the easiest way to understand the East African Court of Justice is to understand it as the constitutional court for East Africa. The treaty is binding, therefore it is law. Any violation of the treaty and any complaint about the violation of the treaty can be adjudicated by the East African Court of Justice. And every citizen of East Africa has a right to seek redress in the East African Court of Justice or to assert rights that are enshrined in the treaty establishing the East African Community. As a matter of live testimony, you know that apart from being a lawyer, I'm also a politician and I lead a political party. I'm grateful to you, my Lord, for reminding the participants here that I'm a lawyer. One of the challenges we face as politicians in Uganda is that you have a very high burden of proof to show that you actually went to school. Apparently, when we get appointed to political positions or when we are elected, we behave as if we are not educated. That is not an entirely untrue position. So if you are an educated politician, you have to keep on reminding people that actually you are educated. I lead a political party known as the Democratic Party. And one time, we held a meeting of the party and realized that the manner in which our representatives to the East African Legislative Assembly were being elected violates the treaty. Like well-behaved people, we went to the offending party, namely the National Resistance Movement, and met the then Secretary General, Amama Mbabazi. And we told him that it was wrong for the National Resistance Movement and the Forum for Democratic Change to simply go to Parliament and share the 9 seats in a proportion of 6-3, and then claim that they are representing Uganda, because the treaty provides for shades of opinion. And we thought that 2 shades of opinion was not representative enough and was not indeed what was intended by the treaty. So we gave the Right Honorable John Patrick Amama Mbabazi 6 months to initiate changes that would ensure a fair process of election of EALA members. When the 6 months expired, he had done nothing, so we went to court. I would encourage you to read the judgment of the Democratic Party and Fred Dennis Mukasambide versus Attorney General of Uganda, where the only question for the court to decide on was whether the rules for electing EALA members in Uganda violates the treaty establishing the East African Community. It is important when you go to court, you distill the essence of your case. You must locate the fulcrum. A court case is like a door, and the door has hinges. It can have 1 hinge, it can have 2 hinges, it can have 3. If it is a big door, it can even have 5. A good lawyer must determine what the hinge is. That is what is called an issue, which simply means something being asserted by one side and being vehemently denied by the other side. The rest is now a question of proof and a question of the law. And to me, that is the essence of legal practice. Never be scared of lawyers who talk a lot of English. As long as there's nothing clear about the hinge, His Lordship, when he's seated in his chair, is looking for how you influence him to swing the door one way or the other. That is your only role. So avoid being a peacock. You display a lot of feather and no meat. Or like a cake with a lot of icing and really very little cake underneath. This training is timely because you are the new generation of lawyers who are going to practice in the new world. As it has been said, the world is now flat because of technology. Many of you will not need to travel even. You'll probably be having 3D courts. The technology of today can actually bring the court to your car windscreen. There's 5D. You can actually continue driving as you are seeing the entire court in the windscreen, and yet at the same time you are able to see the road. That is the world that Cepil would like to introduce you to. You no longer need to have a law library. We are even trying to change the rules when they are inspecting chambers. Why would the law council come and want to see tons and tons of books? If you have got electronic access to the books, your chambers should be approved. It is no longer necessary to. So we must also update ourselves. The world is changing. Cepil, to the best of my knowledge, is at the frontier of expanding knowledge. I hope today begins your journey with Cepil, that you build a relationship, but also that you support its work, but more importantly, that as a pay forward or a payback, you participate in Cepil's pro bono programs. Because Cepil has got a growing pro bono program to represent poor people. Now that you are here benefiting, we hope some of you will sign up and offer a few hours a year to represent the poor that are always knocking on the doors of Cepil. The fact that you are here means that you are good lawyers. I don't know whether there will be exams. I don't believe in exams, by the way. But the fact that you are here means that you are among the best and that you have been chosen very carefully. The skill that you must need is to argue the real case. The case is not the endless facts that people throw around. The case is that fulcrum. Let me illustrate. Centuries ago, in the 19th century, a dispute broke up between the steamship companies that operated on the Missouri River in the United States of America and the railroad companies that wanted to build railroads to move across that great river. The steamship companies thought that if the railroad is built It will interfere with their business. So they went to court to block the construction of the railroad so that the trains don't launch their businesses. The lawyer for the steamship companies argued for more than 1 hour, giving reasons why the railroads should not be built and why the business of the steamships that moved up and down the river should be protected. The lawyer for the railroad companies spoke for just about 5 minutes. And in his concluding statement, he told the judge, "Judge, the only question for the court to decide is whether those who want to move up and down the river have the same rights as those who want to move across the river." That lawyer was called Abraham Lincoln, and he won the case. It's your duty to identify that important fulcrum. Don't let your brain be like an untended garden with lots of weeds. Focus only on the real crops. By the crops, I mean the material facts. Lawyers always talk about material facts. They are facts that are not material. They can be interesting, they can even be exciting, but they are not material. In our moot courts at LDC, we were always taught to observe the judge. You can tell when a judge is bored. When the judge is writing, then you know that the judge is interested. When the judge is playing with the pen, then you know that you're wasting your time. And you should adjust immediately. So, with those words, I congratulate you again and hope that you will be the champions of ensuring that the rights that are enshrined in the treaty are available to your clients, and that anybody who wrongs your clients by breaching the treaty will not get away with it. I'm therefore very pleased to officially launch this training, and I now await the organizers to bring these materials that are going to be available to you so that we also launch them. Thank you very much for listening to me.
Thank you very much, Honorable Minister, for your words of wisdom. And once again, we thank you very much for taking your time from your busy schedule to spend this morning with us to launch this training and remind us that we should not just be peacocks. If anything, let's be turkeys. Thank you. So I'd like to request Judy or somebody to bring us the source book and the litigator's manual. And Honorable Minister and Honorable Judge and Mr. Gimara, I'd request that we stand, take a picture, and after that I'll invite the trainees to join us. I'd like to invite Dr. Noria to also join us up here.
Thank you, Cepil, and our moderator. It's now my great honor to launch the source book on good governance and rule of law in the East African community and the litigator's manual to facilitate the practice of the law before the East African Court of Justice for God and my country.
Do we have the representative of the Uganda Law Society here? Or someone from the Eacj's office? Can we have somebody from the Uganda Law Society and somebody from the Eacj's office in Uganda?
Okay, you are supposed to receive it. Please come on up. So these are for you.
Thank you very much. We don't have anyone from Eacj's office. So, Honorable Minister and Honorable Judge, I would like to request that we go down and ask the trainees to come and join us for a group photo. Kindly come and join us for a group photo. Can we please get assistance? We need some chairs at the front. Are we ready to project? So what we are projecting is ESCJ as a regional court, structure and jurisdiction. Do you have this? So we are ready to proceed. I'll be taking you through this session where we're going to look at the East African Court of Justice as a regional court. We are going to look at its mandate, its structure, as well as jurisdiction. Like was mentioned earlier, this is the fourth training that we are undertaking, and we've tried to do our best to ensure that we train advocates from all the EAC partner states, resources allowing. And we also hope that you'll make good use of the resources that are being shared with you, but also make... Can they do it? Oh, it's this? So I just have to move like... but also make the East African Court of Justice website your friend, because it's on the website that we have all the information, but most importantly, the jurisprudence of the court. And we always have, on a regular basis or just before our court sessions, we have briefs on the matters that are coming for hearing. So with that, I'll proceed. So our court is the regional court, and the judicial body, which is clothed with powers to determine and resolve any disputes that arise. Our court, like was mentioned earlier, is over 20 years old, and it was established under Article 9E of the EAC Treaty as an organ of the community. So just as we have the parliament, the judiciary, and the executive, at the EAC level, we have the court, we have the Legislative Assembly, and we have the Secretariat. So as the principal judicial body, the Cepil-Eacj has the primary role of ensuring adherence to law in interpretation and application of and compliance of the treaty as provided for under Article 23(1). Our treaty can be found on our website, or if you use Google, you'll definitely get access to our treaty. And we have initial jurisdiction mandate with respect of interpretation and application of the treaty. As we go along, you'll also realize that you do not have to exhaust national remedies to access our court. You can come directly to the East African Court of Justice. In 2007, the treaty was amended to include the appellate division of the court. And in that amendment, we now have 5 judges serving in the appellate division from 5 partner states. And in the first instance division, we have 7 judges. So the maximum number of judges we can have in the appellate division is 5 judges, with 10 as the maximum we can have at the first instance division. And during any sitting, a complete bench in the first instance division is 3 judges and 5 judges from at the first instance division. Currently, all partner states are represented at least at the first instance division, because we have 7 partner states, but at the appellate division, we only have Burundi, Rwanda, Kenya, and Tanzania, as well as Uganda. However, these positions can be held on a rotational basis upon the decision of the summit. The summit is the one that appoints our judges, but this is on the recommendation of the partner states. So what happens is that when we have a vacancy at the court as a result of either retirement or end of term, then when we notify the partner state where that judge who has vacated the court is from, and we notify them of the end of term and request them to nominate a person of integrity. From Uganda at the moment, we have Justice Cheborion, who was here to officiate over this session's opening, and we have Justice Wabwire. Justice Cheborion is serving as a judge of the appellate division in the Cepil-Eacj, and he's also a judge of the appellate court in Uganda. And we have Justice Wabwire, who is serving as a judge of the High Court at the International Division in Uganda, who's serving as a judge in our first instance division. So as the trial court, our first instance division acts as a primary fact finder. So when a party first introduces their matter before the court, the first instance division will determine this matter. And after hearing and studying the case, whether or not the party has a legitimate basis to bring a claim or reference to the court, this shall be a determination of the court. What that means is that as the registry of the court, when we receive a matter that has been filed, it is not our place to determine whether or not that matter meets the required, ingredients to be filed in our court. That matter will be listed for hearing, and it is the judges who will determine. And I believe that differs from other jurisdictions, where once you file your matter at the registry, then the registry will determine whether or not that matter should be considered for hearing by the court. And that is a different case for the East African Court of Justice. So the decisions of the first instance division may be appealed to the appellate division of the court. But that said, a lot of people have asked whether our court is also an appellate court for matters that have been decided at the national level. And that is not the case. We only receive matters from the first instance division for purposes of hearing on appeal. And at the first instance division, like we said, these are matters that are introduced in the first instance. So we do not receive any matters that have been determined at the national courts for purposes of appeal. However, we have had situations like in the famous case of Martha Karua, an election petition matter that went up to the Supreme Court of Kenya, where she brought a matter to our court on the basis of the fact that the principles of the community had not been upheld when the Supreme Court was deciding on her matter or when they arrived at the decision. So it was not an appeal, but she was bringing in a fresh matter, challenging the fact that certain aspects of the treaty had not been adhered to during the determination of this matter. So the appellate division of the court has the jurisdiction to hear and determine appeals from the judgments of the first instance division, as I mentioned earlier. Then it also has the jurisdiction to provide advisory opinions as requested by the council or the summit as provided for in the treaty. So in terms of opinions that are being provided, there are situations where the summit is not very clear about certain matters in the community. And it will request for an advisory opinion through the Secretary General to the East African Court of Justice to guide them on how best to approach that particular matter. And that advisory opinion shall be considered by the Summit of Heads of State or the Council of Ministers when determining an issue in question. In addition to that, the appellate division also entertains preliminary ruling requests. These are the so-called case stated from the national courts of the partner states. And the purpose of this is to assist those courts to authoritatively interpret the treaty in cases which are otherwise before the national courts. And Dr. Honoria is going to have an opportunity to get into details of how to file a preliminary ruling request. And this happens in situations where a matter, a national court has been seized with a matter. And in that matter, there are matters relating to the treaty's interpretation and how the treaty is applied. So before that national court can make a decision on that matter, then a request will be made to the East African Court of Justice for their interpretation, or to also assist them in determining the decision in that respective matter. That, like I mentioned, is one of the jurisdictions of the Appellate Division. In addition to that, we also have arbitration matters that are handled by the Appellate Division, and in this case, the Appellate Division becomes an arbitral tribunal. We've had situations, or if you followed some of our online webinars with the ELS, there are issues that have been raised as to whether there's no conflict if the court is an arbitral tribunal and at the same time is able to handle a matter that has come all the way from the first instance division. I would like to say that where a matter has been handled through arbitration and concluded, then there's no likelihood, or with our experience so far, for the matter to come to a court. However, where arbitration fails, and this matter comes through the normal hearing channel of the court, then the judges who sat in the arbitral tribunal will be excused from handling that matter when it comes before the Appellate Division. I'd also like to mention that one of the other jurisdictions of the first instance division is to handle court-annexed mediation. And before a matter can be heard, the principal judge, who's usually the presiding judge, will first ask the parties to opt for mediation as a way of resolving their dispute. But where the parties are not agreeable to that, then the court will proceed with a normal hearing. The challenge we have had so far, we have most of our matters that involve the attorney generals from the partner states. And usually the instructions they have is the matter must go for hearing and concluded. So we need to have the AG's office also opt for mediation as a way of handling some of these matters, and also give their officers or the attorneys instructions for this. We find this is the best way to handle some of these matters. It's not time consuming, but also then there's a lot of costs that are saved. And as you'd understand ADR and its benefits, this would be the best way to handle some of these disputes. So the Appellate Division will entertain or allow appeals from decision of the first instance division in instances where the parties are seeking to clarify points of law, to establish whether the court had jurisdiction to entertain the case, and to establish whether the first instance division committed any procedural irregularity in hearing the matter. This division has the power to confirm, deny, or change decisions taken by the first instance division. And once the Appellate Division has made its decision, then it is considered as a final decision of the court. So, okay, looks like that's the end of those slides, so I'll just proceed with what I have here. So I want to talk about our registry. So our registry is headed by the registrar of the court, like is in other courts, and the registrar is assisted by the deputy registrar. And we have other staff as well who are servicing the registry. The court also has sub-registries in 5 partner states so far. That is in Uganda. We had our sub-registry at the Supreme Court premises, but I think because they are going through renovations, They are currently, I think, located in Wandegea as we wait for a new location for a sub-registry. We also have sub-registries in Kenya, in Tanzania, in Burundi, and in Rwanda, and we are yet to open sub-registries in South Sudan and the Democratic Republic of Congo. So what is the purpose of these sub-registries? Our court is a community court. So we service East Africans, and we've found the need for bringing our court closer to the people. So with the establishment of these sub-registries, then you do not need to come to Arusha to file your matter before our court. If you go to our sub-registry, there is a clerk who is manning that sub-registry. File your matter at that sub-registry, and we'll be able to get that file in real time and schedule a hearing for that matter. So far, we have not had any major challenges in terms of manning our sub-registries, and we are doing our best as a court to fully equip our sub-registries so that we can have hearings conducted at the sub-registry. And this is a request that has also been brought forward to the Chief Registrar of the Judiciary of Uganda to be able to give us sufficient space so that where lawyers or other litigants are not able to travel to Arusha, then they can appear before the court at our sub-registry premises, which will be fully equipped for this purpose. We do not want situations where you're appearing before the court at a certain location where there's just so much noise and distraction, because that does not give the court the due regard that is supposed to be given to it. So the registrar is responsible for the day-to-day administration of the business of the court and will conduct other duties as allocated by the treaty and the court's rule. So our temporary seat is in Arusha, and it's temporary because the summit has not yet decided where our permanent seat will be. And it is at the seat of the court where we have, it's at the temporary seat of the court where we have our courtrooms as well as the registries. The registry. So I want to speak briefly about the jurisdiction of the court, but Dr. Noria will get an opportunity to also delve into the details of that once he provides his training. So as I mentioned earlier, the primary role of the court is to ensure adherence to law and interpretation and application of and compliance with the treaty as provided for under Article 23(1) and 27(1). The ESCJ is expected to restrict itself to the boundaries of its jurisdiction as set forth in the treaty. So where a dispute has been presented before our court, the initial issue that should be decided upon is whether the court has jurisdiction to deal with the dispute. And I believe this is the case in all courts of law. So jurisdiction in this case tends to be classified into three categories, and that is subject matter, territorial, personam jurisdiction. In international courts, such as our court, this has morphed and translated into jurisdiction ration material, ration tempori, and ration personae. If our court finds that it has all the three jurisdictional categories, then it will be determined that it has jurisdiction to entertain a claim or a reference. So looking at jurisdiction ratio materia, the jurisdiction is the power of the court to entertain and decide on the subject matter of the complaint before it. So as a court, this jurisdiction is located in the reading together of Articles 23, 27(1), 28, 29, and 30. And these provisions locate the subject matter of references that can be presented before the court. So if you'll allow briefly, okay, I won't read that because I think we have that. We have Articles 28, 29, and 30 of the treaty. Oh, sorry. I think you moved ahead. Eh? Yeah, it's just that on my slide this appears right after personae. So in the case of references by natural and legal persons as provided under Article 30, this ration materiae is the legality of any act, regulation, directive, decision, or action of a partner state or an institution of the community. So if you are to challenge these particular acts, then these will be entertained before our court. In addition to that, you have to be able to show that grounds that such, you should be able to present grounds that such act, regulation, directive, decision, or action is unlawful or is an infringement of the provisions of the treaty. Going forward, we also have, in advisory opinions, the ratio materiae is met where the opinion requested is in regards to a question of law arising under the treaty which affects the community. I think that is clear, and I managed to mention it earlier. If the heads of state who are members of the summit or the members of the council who comprise of the ministers of the EAC have found that there is need to determine a question of law that arises from the treaty and affects the community, then a legal opinion should be sought from the East African Court of Justice. I also want to discuss briefly the jurisdiction ratio personae, which speaks to who can appear before the court as a party. So these include partner states. We have the Secretary General, but we also have natural and legal persons. So Article 28, 29, and 30 delve into the details of who the parties are that can bring the matters before our court. So the ratio personae is that advisory opinions are requested by the summit, the council, or a partner state's attorney general, but not any other legal and natural persons. So in addition to the summit and the council of ministers, as I mentioned earlier, then a partner state's AG can also file for a legal opinion, and this is through the Secretary General. We have cases. We have the Secretary General of the EAC versus Consolatrice Uwizeyimana, as well as Legal Brains Trust versus the AG of Uganda, that all look into this jurisdiction aspect. And this can also be found on our website. I would like to briefly talk about the issue of resident and say that it is only a resident of the EAC who can file a matter before our court. We've had matters where it has been challenged, and some parties have argued that as long as you're an East African, it doesn't matter where you are, you can bring a matter before the court. But that was challenged by the judges of our court, who found that you only must be a resident of the EAC to be able to successfully bring a matter before our court. And it doesn't matter whether a Ugandan or a Chinese or a South African, as long as you can prove that you're a resident in the region, then you can file a matter before the court. And we have legal brains also. I think Dr. Noria will be able to delve into that case as well to elucidate more on that issue. I would also like to talk about the ratio tempori. Yes, so this jurisdiction is the jurisdiction that focuses on the temporal parameters of the dispute before the court, such as time bar or limitation. And the jurisdiction ration tempori operates twofold. First of all, cases that are filed before our court should fall within the temporal jurisdiction if they occur subsequent to the treaty coming into force. Secondly, there is a strict 2 months rule that guides the exercise of the temporal jurisdiction in respect of references. So the court considers the 2 months time limitation in Article 32 of the treaty to address jurisdictional objections based inter alia on short temporis and the inapplicability. That is Stephen Dennis versus the AG of Burundi, reference number 3 of 2015. So there are issues that have been raised, and through our trainings, one of the questions trainees have asked is, how does the court handle, any infringement that is continuing, especially where we have the 2-month limitation period? And the court in its various decisions has held that the 2 months counts from the time the infringement has been established, and that is the basis for which the time limitation will apply. And it is on that very basis as well that the judges will determine whether the matter that has been filed before our court falls within the time limitation period. So the court has held that the time limitation cannot be applied to every instance in the treaty. It does not apply to proceedings under Article 31 of the treaty concerning disputes and labor relations between the EAC and its employees. This was decided in the Secretary General of the EAC versus Angela Mudo. So any matters relating to staff disputes, these will not be subjected to the 2-month limitation period. Article 31 of the treaty does not impose the same limitation as Article 30 does, and the court has rejected the arguments that an Article 31 claim was time barred under Article 32 2 months limit, and that is the same case of Angela Amudo. So when we talk about jurisdiction reserved to partner states, Article 33 of the treaty limits the jurisdiction of the Cepil-Eacj where an act, regulation, directive, decision, or action has been reserved under the treaty to an institution of a partner state. So the reserved jurisdiction operates in 2 ways. I'm having a challenge in having what I have here read the same as what is being shown on the screen, so you'll bear with me and I'll just give you on the basis of what I have before me. So first, the matter is one, the treaty reserves jurisdiction to the partner states. For example, as I'd mentioned earlier, we have the challenges of various questions, and our chief guest went into the details of the nomination of East African Legislative Assembly members. So where in Uganda, at the point of nomination of MPs to serve at the assembly, there's been a challenge in terms of how the process was undertaken. That is a challenge that is subject to a national court. That is not a matter that can only be entertained at the East African Court of Justice. Secondly, the matter relates to the enforcement of decisions of national courts. Those also are also matters that are concerns of the national courts. We also have the third, which is the jurisdiction that is exercisable by both the Cepil-Eacj and the national courts. This is manifested in Article 33 and 34 of the treaty, where the Common Market Protocol can be lawfully invoked before the national courts. So we have cases where we have traders disputing over maybe it's an existing NTB, and this is not something that is only reserved for the East African Court of Justice. Also, a national court can be able to determine that matter. I'd also like to mention that every partner state that has acceded to the treaty has an East African Community Law Act. So that act is what we use at the national courts to be able to challenge certain matters relating to integration, but at the national level. Moving on, when it comes to recourse to redress in national courts, this is not a reserved jurisdiction under Article 33 and 34 of the treaty, as the national process only supplements the Cepil-Eacj. So the fact that the person whose rights and liberties recognized under the Common Market Protocol can seek redress in their respective partner states does not oust or infringe upon the jurisdictional interpretation of the court. So the fact that you're able to bring that matter before the national court, but you have chosen to bring that matter before our court, there is no reason why the East African Court of Justice will not be able to entertain that matter. So that brings me to an end of my presentation on the East African Court of Justice, and I'll be happy to get any questions from you. Otherwise, in terms of our jurisprudence and more details on our jurisdiction, we are going to use these 2 days, which is now a day and today afternoon, to delve into the details of this with the assistance of Dr. Honoria and Mr. Gimara. Thank you very much. Do we have any questions? Yes. No, I can't.
Thank you very much for the presentation. My name is Judy Mbabali. I have 2 questions. One, you've talked about residents filing matters in the East African Court of Justice. How would you determine that a company is a resident or not? I would wish to be guided. Then 2, you've talked of countries like DRC joining the East African community. Some of these countries use French, and most of the judges, our judges, don't know French. So how, don't you find that a problem? How would you solve it? I would wish to know. Thank you very much.
Thank you. So the Summit of Heads of State in their 20th ordinary meeting decided that French and Kiswahili will be the official languages, the additional official languages of the community. Now, what that requires is that the treaty be amended so that we are able to use these languages, first of all, as languages of the court as well. Now, the process of amending the treaty is a very arduous process. It's already a year since the summit took place. The treaty is yet to be amended. We have DRC as members of the EAC, but in addition to that, we have started receiving matters. from these countries. So what does the court do under such circumstances? We are looking at having translation services adopted by the court for purposes of entertaining that are not in English language, that is in French. So that is something that needs administrative arrangements to be put in place so that we can be able to entertain those matters in those respective languages. Now, how do we determine whether a company is a resident in EAC? And I think for resident, that is determined by registration. So you have to be able to be registered in an EAC partner state and prove that you are registered in the EAC, in one of our partner states. Yes.
Thank you very much. My name is Anne Karunji. You mentioned that there must be 3 elements of jurisdiction that must be proved for a matter to be entertained by the court. So my question is, when I file a reference, do those 3 elements, must I prove all of them at any particular time? Must they be present, all of them, at any, or one can suffice, or 2? Thank you.
So when we're talking about these elements, number 1, we have time limitation. Your matter should really have been filed within the time limit, so you cannot escape from that. Number 2, whether the matter that you have filed serves or satisfies that it's an infringement or does not comply with the treaty. And then there's also, I think that was material, there was limitation, and who is filing these matters. So you cannot file within time, and at the same time you do not satisfy that you're a party who should be able to file this matter. So I think it's inevitable that the 3 have to be satisfied for a matter to succeed for hearing before our court. Yes.
Thank you so much. My name is Chemisto Shoaib. You talked about that it's the court which determines whether a matter has been properly filed. So what I wanted to know is, at what point does court decide? Do we just receive communication this side that the court has read through your matter and it doesn't fit the purpose, or there is a hearing where I appear and I defend my case that actually my matter is fit to be presented in this court? That's just. Thank you.
Okay, thank you. So unfortunately, I didn't. But what works is once you've filed a matter, so the first step is that there will be a scheduling conference that will be held with the presiding judge. So during the scheduling conference, then both parties will present the basis for which the matter has been filed. So if you are the person who has brought the reference, then you should be able to put the issues that should be determined by the matter, and then the other person's response. And then the court at that point will ask whether you want to proceed by mediation or not. If you reject to the mediation, then court will proceed to schedule a hearing where your submissions will be determined, and it is at that point where the court will decide whether or not you've satisfied the various ingredients that have to be exhausted before you can file the matter. So you're given an opportunity to be heard. Any other question?
Thank you so much, Worship. Paul Muchivi is my name. Just a follow-up question on his from the response. At the scheduling conference, can't I intimate court if I'm the opposite side that his matter is not worth to be determined, or for instance, issues of jurisdiction and what have you? Can't I raise it and ask the court to have it struck out? Or court will give all of us a benefit of doubt to determine on its own. If the opposite side, I'm sure his matter is not worth or cannot be entertained by the court, can't I move court on my own as the opposite side?
Dr. Honoria, are you able to respond to that?
Quickly answer that. It's actually at the scheduling conferencing that you can raise the preliminary objections. And if one is of jurisdiction, then that's one of such objections. So you can raise it at that point, then it becomes something the court handles. And the court will always dispose of these preliminary objections as to jurisdiction. Because once that is sorted out, then that means the matter is a non-starter. Yeah, so it will be dismissed at that stage. But you can, so the earliest you can raise this at that point.
Thank you. And I want to welcome Mr. Muchivi to this training. Mr. Muchivi has been somebody that we've connected with on several occasions. He's done a lot of research on the functioning of our court, but most notable, it's on the implementation of the decisions of our court. So if you want to understand exactly how partner states have performed in terms of implementing our court decisions, then Mr. Muchivi is the person to talk to. Thank you. So I believe that's it for the questions. And I want to thank you all for your kind attention. I'm here with you until tomorrow. It's exactly 5 minutes past 1. So I would like to request that we move on to the restaurant, have our lunch for 1 hour, and make sure we are here at exactly 10 minutes past 2. I believe Judy has some coupons. Judy is right at the exit, and please pick a coupon to enable you have lunch at the restaurant. Thank you very much. I hope you all have the programs so that you're informed of what's going to happen in the afternoon.
that the Secretary General is not living up to his or her obligations under the treaty, or the community, you sue the Secretary General. Don't sue the Secretariat, don't sue, so it's a body corporate. Yeah, so it's been explained in that case. Timothy Alvin Kahoho, this is the one who actually challenged the inclusion of South Sudan as a partner state. And the court basically, I think, tried to navigate the policy. That's none of our. We're not based to judge whether a state, a party state that's applying for membership. As you can see in 6, mutual trust, peaceful coexistence, peaceful settlement of disputes. These 2, I think, were dealt with in the case of where Rwanda closed the border. Those 2 principles. The problem I have with that decision, it's not detailed enough for anybody to really bite on. There's more like bone than flesh. Yeah, because it was exported, Rwanda government was deemed to not have put in a defense. Until I was in Kigali, I don't know, I discovered why. The Rwandese don't understand affidavits. The concept of affidavit is alien to the legal system. Now, you are supposed to, when you file a reference and you are alleging that there are violations of the treaty or there is an infringement of the treaty, you must indicate by way of affidavit, just like you do with constitutional petitions. You attach an affidavit detailing the evidence or the statements as to why you believe that the particular act is unconstitutional. So you must demonstrate by affidavit. They don't understand the concept of affidavit. I used to wonder why we would get statements of defense that were packed with like submissions. So for them, it's alien, affidavits are alien to them. So I think by the time they submitted those things and then had to withdraw them at the end of the day, they had no evidence, they had no defense. So I remember when I was there, I actually took the whole afternoon of the second day just to go through affidavits. Luckily enough, there was a Ugandan there called Martin Okumu. He left here, went and enrolled, did his bar from the Rwanda bar and stayed. So he's been there 10 years. Of course, I think he keeps coming in. So he was one who was with me guiding. Even the registrar of the court there also now understands what affidavits mean. But that was understandable, their problem. They still have the French elements. Even their equivalent of ECMIS is different. For us, our ECMIS, you do your documents, PDF them, then upload. For them, their equivalent is word-based. You must type everything on it. So there's nothing to upload. So you see, that's why they don't understand. So those concepts of affidavits would be alien to them. So anyway, so it will be interesting to see good governance, what we'll be looking at. This principle has been applied. Now, one of the things that we need to note at this point, the community decisions. The East African Community Law, the decisions from organs take precedence over national law and national decisions. So when we'll be looking at the preliminary ruling requests or references to the court from the national courts, to the East African Court of Justice from the national courts, it's on the basis that once the national court issues a decision in regards to that ruling, issues a ruling based on respect of that request, that ruling is not only binding to, say, Uganda, it's binding to all the partner states. And therefore, it then has precedent over another decision. So if another national court issues a decision that is contrary to that ruling, that decision is of no effect. So that's why we'll be looking at that, the reason why you have that preliminary ruling, that you want one uniform interpretation of the East African Community Law, which will then bind everybody else. So they have precedent, that is Article 8.4. Now, one of the things that partner states were required to do was within a specified period were to domesticate the treaty. So we have the acts that domesticate the treaty. So you have the East African Community, Treaty on the Establishment of the East African Community Act, that Kenya and Tanzania, and then the East African Community Act 2002 of Uganda. Even when they amended the act in 2006, Kenya issued a specific act to implement. I think Rwanda and Burundi, because of their civil law mentality, you know what the difference? Those of you who did it, we are dualist. We need a sophisticating law. In Rwanda, they are monist, given their civil law background. So typically, the ESC would apply domestically. But for the protocol, I remember there is an instrument they issued to domesticate it. I keep telling myself I need to locate those laws and put them on the readings notes. Let me keep that in my mind. Each training I discover something I need to add on the readings. Yeah, so you can see that you cannot refer to your national law. Just go back to. Okay, so protocols. Now just imagine the amendments in your municipal law. That's what the protocol does literally. We're adding something or removing something that is in the treaty. So you have protocols which sometimes add on, because if you remember the East African Community Treaty mentions common market, customs, territory, and all that without any detail. So the first two protocols give meat to those provisions. So the 2004 and 2009. But there are also other protocols on monetary union, as I have mentioned, and then the one on the political federation. But beyond that, there are other protocols as well. And one of the things, because I remember one time someone went to challenge a protocol immunities of officials of the community and all that, and they were challenging that is not, the issues of a protocol was contrary to the treaty. And the court pointed out that the partner states can issue protocols in any area of cooperation within the community. So they are not bound by those ones which are specified in So there are others. That's gone off again. Anyway, so beyond the protocols, you have the acts of the community. Now, the acts of the community, the best example is you have the parliament, which issues legislation. The primary legislation is acts. So the East African Legislative Assembly, as the law-making organ of the community, issues acts of the community. So for instance, the East African Community Customs Management Act is one such an act. Okay, so for instance, the protocol is the import in the BAT versus Attorney General of Uganda, the court explained. I like this quotation. The implication of the customs union and the common market. That a customs union is a geographical area in which the partner states engage in trade amongst themselves in the form of, that is free from tariffs and non-tariff barriers and up tariff on goods from non-partner states. So basically what you're supposed to do in a customs union is remove the tariffs. Those things which involves like taxes and because some of you who came at the tail end of this morning's launch, for instance, Uganda, under its new VAT Act, the amendment in 2022, removed tax VAT on educational materials coming from the East African partner states. So that's taking out a tariff, removing it so those goods can now move in and out, educational materials. Yeah. When Kenya issued its digital services regulations in 2020, that included everything. Then they amended it and eventually issued new regulations in 2023, and they have now excluded educational materials from taxable digital services. So anybody supplying, downloading educational materials, those are now free of any tax. There's no VAT levied on those digital services. So you can see there's so many things. So you look at those and you say, understand what the implications are. Now, the non-tariff barriers are those annoying things like what is happening at the border. Where you are sending goods and then they're telling you need to do this, we need to do this, or you find the speed is not equivalent, you find your roadblocks, that delays. So that they're not based on tariffs, they're just there, the NTBs. Now, then secondly, common market is a customs territory that's characterized by the free movement of goods, capital, services, labor, persons, as well as the right of residence and establishment. Now, I can tell you one of the most effective countries in doing this is Rwanda. We can say whatever we want about that country. But for me, I know that each time I go to Kigali, it seems like the country is collectively traumatized. I don't know why, because maybe they have been living under too much of a dictatorship, but they know what they are doing in terms of. When we were there, I was shocked that even the Cameroonians practicing law. Literally everybody who wants to go and practice law, if you can manage to survive in Kigali, you can apply and go. So they have that. So the free movement of people, the free movement of services, the right of establishment. You can go and establish yourself there. Reside there. While you are there, the 2022 foreign exchange regulations allow you to move your money freely. Yeah, you wake up one morning and someone is saying they're kuanjularing, yep, $5,000 across. Someone has passed on, you send money. Someone is suing you for debt, and the court has granted the damages. You say, okay, let me go and look at my account and send the cost of the. When I looked at that list of what you can do as personal transactions, it was baffling. You can do bequests, you can do dowry, you can literally anything that you'd think of, contracts. And this is in the foreign currency. We're not talking of so that mobility, that capability to do these kind of things. Any of you with excess money, go and invest in the securities exchange in Rwanda. Don't worry, when eventually you sell those shares, the capital gains exempt. That shows you how they're interested in getting you to invest. Because by the time you dump there $1 million, and even if you eventually earn and resell them at $1.5 million, what value has your $1 million done to the economy over time? It's more than what you are. So they're not worried about your capital gains. So just think about that. So that's what the CUP and the CMP did. Now, for us here in Uganda, I don't know how many of you saw that income tax amendment bill of 2023. I know you saw the comments from ULS about digital services, about the taxing collective investment schemes. That's the wrong approach to do things. If you want to spur investment, encourage people to invest. Now, that's what you see. When you say free movement of capital means people investing. Free movement of goods, people moving goods in and out. I met a young man in Rwanda who was very interesting. He said that he told us that it took him 6 hours to license a business in Rwanda. And it took him 2 years to try to license the same business in Kenya. But then he discovered that the trick shouldn't be for us to begin thinking that we can establish ourselves everywhere. The right of establishment. You don't have to establish yourself everywhere. Just enter into partnership. Find someone who has the same ideas in Kenya. Is likely to be able to set up the business quickly, then you partner. Share the idea, partner, grow on profits, and you have established yourself indirectly. Free movement of services. You should be able to offer services. CJs is now in Nairobi. So I met the young lawyer, told me I'm representing Mandela here. Now, his biggest problem was that he can't get pineapples out of Uganda. They want Ugandan pineapples. They are sweeter, they are more less toxic, but they can't get them enough into Kenya. Kenya is saying we have mango, we have pineapples here. Why are you bringing pineapples out of Uganda? So that's what the common market. It's one big market taking away all this. So you need to understand this, because if you are going to practice in this area, it's beyond understanding just the law, but you need to understand the nitty-gritties of what the law provides, but also what is happening domestically. There's quarrels about eggs, quarrels about milk. Those are just standards. So you need to. Okay, so this is the Community Act. As you can see, there are quite a list, and this is not exhaustive. The early ones, you see the ones of 2003, the Customs Management Act, which is actually the foundation of trade in East African community. The East African Community Customs Management Act. It has been amended several times. In the materials I will give you the original act plus its amendments, because I've failed to track whether there's one which is latest. There's an amendment of 2021. But what this act does is it empowers the customs authorities. So in this case, in Uganda, that would be the Commissioner for Customs, would be literally the person with the powers under this act, to do so many things. Now, I think our Commissioner for Customs hasn't really exhausted all the rights and powers under that act. Kenya Commissioner for Border Control and Customs is literally everywhere. He's designated transit routes, he's designating so that you are exporting goods, this is where they will pass. So that they don't pass the normal routes, so that the goods move faster. He's designating his special economic zones, boarding areas, and customs ports, issuing guidelines. I know we have the Uganda Free Zones Authority, but when I talk to them, they seem to be like fighting against the trade minister and fighting customs. They were trying to create their own independence. Yeah? So you need to, so that's very critical, because those are all powers actually coming from the Customs Management Act. Yeah? I don't know how many of you read the case of Testimony Motors versus Commissioner for Customs. It was originally Testimony Motors versus Commissioner for Customs 2013, 12 and 2013. Then the appeal was Commissioner for Customs versus Testimony Motors. It was recently ruled upon by the Court of Appeal. People don't, where do you live? Don't people import cars? How do you get charged for your car? Do you go to the UR and tell him this? I brought my car from Japan, it was $5,000, and so you tax. Now, URA used to have its own valuation. So you go to URA and tell them that, my car, I've brought it. I've negotiated, I've brought it at $10,000. URA would go to their 500-page document and say, no, this car is valued at $20,000. So this is the tax you're going to pay. So that was the dispute with Testimony Motors. So Justice Mandramazi was then in the High Court ruled for the car companies that the valuation method is the one specified in the East African Community Customs Management Act. The commissioner appealed, the Court of Appeal upheld the decision that you couldn't jump down all the other valuation methods and ignore the valuation based on price. The first valuation is price. If someone tells you this is how much I bought the car, before you do other estimates and all that. And I will give you other decisions where courts have handled decisions based on the ESC Customs Management Act. So there's a lot of jurisprudence going on. So if you ever have disputes, with your clients has disputes relating to customs duties, first of all, note that you don't rush to court. The Act has an internal system first. You first engage the Commissioner for Customs to resolve that dispute. It's only when you fail that's when you go to court. In fact, for tax, you might find that you might first have to go to the tax tribunal. I don't know about Uganda, but in Kenya, if you find that it's a tax-related dispute and you can't resolve it with the commissioner, you go to the tax tribunal of Kenya, and then after that you go to court. So in one of the cases, they jumped and went straight to court. So you first exhaust the internal remedies, the administrative measures, because the commissioner might resolve it. And you know now there's a ADR for disputes with the commissioner, for customs, or for tax. You can first resolve those disputes. You can agree to ADR. So now one of the things I want to point out here is the last one, the One-Stop Border Posts Act. I'm sure all of you now know that there's only one border post now in Mombasa or Dar es Salaam. After that, your goods come straight to wherever you are. Whether in Kampala, there's no more border post in Malaba or Busia. No border post in terms of physically handling the goods again. They might just allow you through, but in terms of managing to inspect and all that, it's done at that point. So you are there as an office in Mombasa. Now, there will be idea being that if this one customs territory, why are we having these stoppages along the road? Once the goods have entered the custom territory, then they should be able to move freely. So they have issued that One-Stop Border Post. Now, Tanzania has a One-Stop Border Posts Act, domesticating it in Tanzania. We haven't done that in Uganda. I've not seen it in Kenya. There's a Competition Act. We are trying to pass our competition bill here. On the basis of that Competition Act of 2016, Kenya, Rwanda, and Burundi and Tanzania have competition laws. So there's something that can inform what can happen domestically from the ESC. Regulations, directives. Now, regulations and directives are made by the Council. This is usually the Council of Ministers, which includes the ministers of the East African Community. Sometimes, depending on what the subject matter, it could include attorney generals. Attorneys general, it could include other ministers. But these are the examples. Again, they are not exhaustive of regulations. Now, one of the things I want you to note there are the competition regulations of 2010. So the competition regulations that implement the Act. You have the rules of origin, rules of origin rules. These are based on the Customs Union. The One-Stop Border Post Regulations 2017, again, they go back to the Act. Then the two directives. This is just one example of two examples of directives. There are more. The East African Council of Ministers issued close to about 8 or 9 directives in 2014, 2015 up to 2017. Now, if you look at them, they sound familiar. Collective investment schemes, we have now an Act. Takeovers and mergers, we have regulations in that regard in the capital markets. Now, every partner state has used these directives to implement relevant legislation domestically. In Kenya, in Rwanda, if you go through the entire capital markets laws, you'll find collective investment schemes, takeover and mergers. You'll find cross-border introductions. So those are all directives that came out of the community. Now, that's what I was telling you, that if you go to the Rwanda Customs Common Capital Markets Authority Act, as well as I think even I've looked at the Central Bank of Rwanda, you'll find they've captured these directives. Each time directives come out, they capture them because they're important. They speak to what the country should do. Now, all these are part of East African community law. Don't say because it's a directive, it's not. It is part of the... Basically, it means if the directive is issued as a partner state, you must implement it. The organs, those ones I'm sure are not really a difficult one. We have primarily the summit, we have the Legislative Assembly, we have the court, and then we have the secretariat. But in terms of, so it's often you'll find regulations of rules of procedure that are issued for each of these organs. So you'll find the Legislative Assembly has its rules of procedure 2005. The Court of Justice has rules of procedure of 2019. as well as the rules of arbitration of 2012. Now, you'll get on the flash disk a folder that covers the court. It will have the court's rules of procedure, the rules of arbitration. I've even added there the court users manual the court developed in 2020. I'm not sure I have the legislature, but then I'll look at what else I need to give you. Rebecca, this familiar. Rebecca studied ESC community law in Dar es Salaam, so I'm sure they look familiar. Decisions of the court. I have created a folder of what I've been able to, how do I call it, reorganize. Sometimes you get decisions from the way the registrar gave them to me about 3 years ago. They were all over the place. You know, people tend to also do that. I always get documents from people and they are not to my style of saving. I've received documents from someone sends me an email with an attachment and it says scan 0.1. Why don't you rename them? If you download music and I don't know what, it will be say Longoma or whatever, maybe it will say Spice Dana or 001, and now I don't understand what's the song. So don't worry, I tried to reorganize and I've done, I think, 209. So you'll get the folder with 209 decisions out of the court. There are more. I've not included the ones on tax. I've not included other things. But I thought that would be a start of the ones I've so far organized. And don't worry, as it already been explained, this litigator's manual and the source book, they are in PDF version. We'll give you the PDF. That one also is on the separate folder, the resource materials. Whatever you find there as a case, if you put the cursor over it, it will point something like a hand. Because if you click, it takes you to the website of the court. So then you can read the original case. Now, the bit about it that it helps you try to navigate. If you went to the court on your own and type the first division, it will just give you all the cases. You don't know what it is about. You don't know what the subject matter. Of course, so you might have to just begin reading and trying to say, will this give me the... Or you can type in, like I find always with the ULI. You type in and you say you want arbitration. It gives you all the acts, gives you all the judgments with no clear identification of what you are looking for. So the hyperlinks, since you already have a substance, a heading or basis for the case, it will make it easier when you're now reading the full case that this is what I'm looking for. And the cases, if those of you have seen, we give you the page numbers so that you don't begin saying, oh, for this particular principle, I have to read the whole thing. For that particular principle, when you ask the hyperlink, you can go to the pages indicated. Because the case might have other things, same different principles. So the decisions are there. The organs, institutions of the community. As I said, the organs are very straightforward. You have the summit, the council, the assembly, and the court, and as well as the secretariat. But there are institutions which are created under the treaty. And this is the list. I like the last one, the surviving institutions, which include the East African Development Bank, Lake Victoria Fisheries Organization. This one's never collapsed, never died with the collapse of the previous community. They stayed on, including the Inter-University Council. I know it's listed there, but I think it's just because it was renamed, but it was always there. I remember when I was in Makerere, there were 3 students from Tanzania, and there would also be equivalent Ugandans in Dar es Salaam. Each year there would be that swap of at least 3 students. I don't know what happened these days. But as you can see, these are the institutions. And one of the things that you notice there is that often there is a law which sets up these institutions, either a protocol or a protocol and an act. So you see, for instance, you have a protocol on the East African Commission, Kiswahili Commission, but I have a feeling there's an act. Just like you have the protocol for the establishment of the Inter-University Council 2002 and there's an act in 2009. So bear in mind the protocols are issued as appendages to the treaty and the acts are issued by East African Legislative Assembly. Now all these are Yeah. So there are limitations. You just need to pay attention to that. What can each institution do? Just like we talk about separation of powers, one institution cannot step into what the other institution is doing. So the very first one, as you see, it was wrongly citing, instead of citing Secretary General of the community, it said East African Community. Mwatela, this was the time when a number of East African Legislative Assembly members wanted to pass a private members bill. The Council of Ministers took it up and then later on abandoned it, withdrew it. But the council said, this is our bill. Why are you abandoning it? I mean, the assembly said, this is our bill. How come you take it over and abandon it? So there was that debate, what's the separation of who has powers? And remember, we always assume that, like in our case, legislation seems to come from what? From the executive, because that's where we're driving it from. But the actual lawmaker is actually the parliament. The problem is the parliament can initiate its own laws, unless you have those private members' bill, which they're subject to, whether they meet, whether there's any financial obligations in Uganda. So here, that was the discussion. What's the split between the functions of the two organs? As I told you, Timothy Alvin Kahoho, this was the summit and the secretariat. Professor Elias Bizu. Now, one of the things I did point out that for the institutions of the commission, of the community, you can actually sue the institution. Because if you go to, the Deputy Registrar mentioned Article 30 of the treaty, where you can bring a reference against a partner state, organs and institutions. For the organs and the community itself, it is the Secretary General. But for the institutions, you can sue the institution itself. So in this case, Professor Elias Bizuru sued the University Council of East. But one of the things the court pointed out, that as long as a community institution, legal representation is by the council to the community. The CTC represents the community and its organs and institutions. In this particular case, a young lawyer from Uganda turned up to represent the Inter-University Council because it's based in Kampala. And the court said, we don't see you, we don't recognize you. So they had actually to sort of stay the matter for a bit for the council to the community to turn up. And he tried to argue that there's an able-bodied, person who is best understands the working of the institution before the court, the state attorney, the young lawyer who had been recruited. Court said no. He can sit there with you, but you are the face of the community. You're the one who is representative of the institutions of the community. So from that date onward, the CTC sits, appears for all institutions and the community and all its institutions. I think that is the end of, So I just wanted you, so that you don't really think that East African Community, I know what it is. This is the law. And you can see it's broad. So what I've done in the folders, which you'll find on your flash drives, is to at least compartmentalize, sort of put them in pieces. So where you have the acts of the community, they're in one folder. Where you have the treaty and its protocols, they're in a folder. The court, its rules of procedure, arbitration rules, they're in another folder. The cases are in another folder. The other folders that I'm going to create a folder for the domestication. There's a folder for domestic people arguing the community law before national courts. I think there's a folder on enforcement. That kept being asked that question. That can you enforce the decisions of the East African community? And where? Don't worry, you can do that. You get your judgment from the decision from the East African Community Court, Court of Justice. Just go back to the registry, the East African Registry in Arusha, and get a decree. Yeah, you get a decree, you go back to a court here and get a decree. Then you come and execute. You just say, okay, where does Uganda have assets and money? Normally, the best place to go is your home country. Because you say you have got judgment against the Attorney General of Uganda, you go back to Kampala and you say, okay, High Court, I've received this decree, want to file it and have it enforced. Through the enforcement process. You go and serve the Attorney General that this is the decree, and you get paid. But it's not as simple as that. Some we have found it hard way. He got some judgment against the government of South Sudan, and of course, knowing there was no money in South Sudan, he had gone to and got a decree from the East African. Now, the decree was supposed to be enforced in the courts of Kenya. I don't know what happened. They came back and filed it in Uganda. So the matter went before Mubiru early this year, and Mubiru said, but there's no proof that there was a transfer of the decree from Kenya to the commercial division in Uganda. Don't worry, I've added that in the folder. So there's a folder. In that folder also you have an attempt to enforce a SADC decision before the court in Zimbabwe. And the Zimbabwean court said, this is against public policy. So the parties went to South Africa and got enforcement from a South African court. So you can actually go back to the partner states to enforce. So there's a folder which has those judgments. I just wanted to show you that you don't have to say, oh, will I be left holding a decree or a judgment which has no value, especially when there's a damages given. Normally, a good number of the early ones were just declaratory, where they will declare that such and such was contrary to the provisions of the East African Community Treaty. And that was it. Of course, you went back and got costs, and you still need to get paid for the costs. But I think one thing that people have shown that Uganda's, East African Community Partner States have not been very difficult to pay things. Unless you are like Professor Nyang' Nyong'o, where the first case, they went to Kenyan government and presented, I think, what, $1 million bill of costs? And Kenyan government said no. But, okay, can we have the next one? So I was just I just wanted to run through that so that you understand that. I know sometimes it's difficult to appreciate what the community law until you understand it. Most of the materials I've indicated there are actually, I've not downloaded everything. I some website of the Cepil-Eacj over time. By the most I've collected over time. Sometimes I have to Google search and hope someone has dumped the act or the protocol somewhere. Because sometimes you go to the East African community and you say, it sounds suspect. Whatever they have on the website doesn't sound like it is. It's unsigned. Like when you're looking for an act. If you find an act which does not bear Museveni's signature, you're doubtful whether it has been assented to. At least let him assent, then you say it's okay. Now we wait for it to be gazetted. But if it doesn't have, you'll begin saying, So I get some of those on the I think maybe the person who was tasked to look for them found whatever he could find and uploaded them. He's an IT person, he doesn't know the implications. So there are some which have yet not been able to upload. There are some which are properly gazetted, like though we see our gazetted laws with the masthead. So it will have that gazette, the head that East African with the gazette number and all that. Those ones, that one now has been gazetted. So sometimes you have two such laws, one which has been gazetted and which has the signature of the partner states. So you ask yourself, which one should you take? So I've tried as much as possible to capture what I can get, but the reality is there's more. Over the next next years, I want to go back and look at all the gazettes since they began being uploaded and begin to track what is relevant, including the deuterations, including there are certain things which they sometimes issue legal notices. Incidentally, the Council of Ministers, when they issue this directive, they issued as legal notices, like the way we would think of statutory instruments and all that. And that is very important information for understanding what the community law is. Most times we miss that part. Okay, so good governance. I think everybody knows what it is. To be governed what? In a good manner. I was looking at the indexes of good governance in East African partner states. Now, the surprise, in most of those indexes, good governance indices, whether it's Mo Ibrahim, whether it is Transparency International, Rwanda does better than us. It's a surprise because everybody thinks Rwanda is a brutal dictatorship. We're actually not doing very well. Of course, South Sudan, and I'm sure now DRC would be at the bottom of the rank. But anyway, so good governance is a principle. I don't want to belabor this because that's what is covered in this volume. We tracked all the the cases where the court has dealt with good governance. Good governance and the rule of law popped up as a result of the court having no human rights jurisdiction. Kataba as the case, where all of a sudden lawyers were trying to figure out how do we argue a matter for which we can't argue human rights directly. So they decided to opt to argue good governance, human rights through good governance. Because if you look at the definition, but just before we get there, good governance is actually a critical part of the rule of the treaty. From the time you are demitted as a state, you must adhere to a listed principles which include good governance. And that's why people have been raising that there are reports about human rights violations in South Sudan where we're demitting them to membership. Of course, they lost that one. There was an interesting case which you'll find in the book where someone tried to raise the issue of good governance under Article 3.3 vis-a-vis Burundi. And the court said, but this is for admission of states. The provision relates to admitting member states. Burundi is already a member state. So what are you asking us to do? You want them expelled? So you can only cite it when you're talking about admitting a partner state. But it's also critical for foreign and security policy, but it's also a fundamental principle and operational principle. That's why Article 6D and 7.2 are often cited. And now, one of the things that I know we can look at good governance and the rule of law and say, okay, so what does that have to do with the regional trade integration? The treaty is mainly about integrating for purposes of trade. So what's the relevance of good governance? Yeah. But can you imagine a situation where there is chaos? Yeah. You imagine, just take a quick example, the riots we've occasionally had here, where people are rioting, burning tires in the middle of the road. How are you going to do business in the midst of that? How are you going to do business if occasionally the government is confiscating your goods and property? The government is not observing due process, not following the procedure set out under the law for purposes of maybe taxing you, placing penalties on you. If they're not going to follow the law and they're operating outside the law, how are you going to do business? How are you going to trade? You wake up one morning and you go into South Sudan with your cargo of goods and they tell you, we can't allow you in now, we're even going to destroy your goods. You're not going to thrive if there is no good governance and the rule of law. Free movement of persons. The best example is Mohochi's case. He turns up here, he's been retained as counsel to represent the suspects in the bombing, the 2010 bombing. He arrives in Entebbe, he's picked off from the immigration and put in a small room for a number of hours and then put back on the plane back to Nairobi. And in his argument was, he didn't even argue, okay, he argued freedom of movement. That was like a side look, but you see, the government tried to argue that they had the powers to determine whom they allow into the territory under the immigration law. But the immigration law sets out procedures of how you deal with someone you don't want, and what you call a prohibited or unwanted migrant. You don't follow those procedures. So what happens to the rule of law? I had an interesting case when I had, which was a Ugandan picked up from here, and he was told, and this is true, they will tell you, you don't need a passport to go to within East Africa. All that you need is your national ID. Especially if you're traveling by road. Of course, if you don't have a passport, you might have to get a temporary document which allows you to enter plane through immigration and enter plane. But you can pick up your national ID, get to the border of Kenya, proceed into Kenya. So this young man picks up, carrying both the passport and ID. He arrives at the Kenya border, he says, okay, I'm told I can enter with the national ID, enters with the national ID. He reaches his Kamanga, now that's entering, that is Tanzania. They told him, no, you can't enter with your national ID. So he says, okay, I have a passport. They look at this passport, there's no exit stamp. There's no exit stamp out of Uganda. They told him now, you can't enter now. You have no, there's no proof that you have left any of the East Africa. So he could now enter Tanzania by virtue of the fact that Tanzania hadn't yet recognized national IDs as a medium for travel and entry into the territory of another partner state. So those are the small things which can become so annoying. You might find that it's easier to just pick up and go. No, just imagine if now, for instance, you wake up as Cafe Javas and say, I need to, CJs, and you say, I need to go and establish myself in Nairobi, and they tell you, no. We can't allow you to do business here. Maybe for political reasons, maybe for... So you can imagine what good governance and the rule of law implies. It has very big implications for what you can do as, for purpose of trading, for purpose of free movement of goods, services, for free movement of persons, for residents. Okay, so, but what I'm going to do, we're not going to go through all this. I just want to show you what the principles are. So Article 6, because these principles have become critical to about almost 70% of the jurisprudence of the court. So Article 6D and 7.2 are almost similar. They're just a few things. One is the fundamental principles and the other is operational principles. So good governance, including, so the fundamental partner states shall include good governance, including adherence to the principles of democracy, the rule of law, accountability, transparency, social justice, equal opportunities, gender equality, as well as blah, 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 human rights. So that's why most human rights litigation has proceeded along. That you don't go and argue that it's human rights, you are arguing good governance and the rule of law, and human rights is... All those things you see, including, means that those are examples of good governance. Good governance as a term is generic. Now, these others are what gives you examples of good governance. If you look at even the 7, partner states shall undertake to abide by the principles of good governance, including adherence to the principles of democracy, rule of law, social, and maintenance of universal accepted standards of human rights. Those are examples of good governance. So if any of those is affected, you go to court and say, well, I've been denied my rights, my right to this and this, right to freedom of expression, freedom of assembly, and it's a mark of lack of good governance or infringement of the principle of good governance. Transparency. Am I forgetting that case of Karuma Dam? I've forgotten. But what he argued was that the award of the procurement to build Karuma Dam flouted Uganda's own procurement law. And the process of award lacked transparency. There was no transparency in the way the award was, the bid, the works were awarded. And so he came back to that argument that the lack of transparency violated the principle of good governance. And the court agreed with him. Of course, by that time, the works were already be going on and all that, so it was just a declaration that he sought. In the Professor Bizru's case, he had wanted the court to declare that he had applied for a job. But you know, all of us know that if you apply for some of these high-profile jobs, they will undertake due diligence. So the Inter-University Council had conducted due diligence. They was insisting that they never gave him a copy of the report. They recruited someone else. They never gave him a copy of it. So he was arguing that that was lack of transparency. The court said, no, most people do due diligence for purposes of, and they don't need to give you the report or give the subject matter the report of their due diligence. So they refused to grant him there. But in the end, even his claim failed for another reason. He was suing under Article 31. Not an employee, not even a prospective employee of the community. You can only bring a claim under Article 31 if you are an employee. So next time you have someone who tells you that they want to sue for failing to get a job, better go through 30, Article 30. Don't go to 31 because someone was applying. Or if someone has left the work of the employment of the community, you rather find another way of suing, but not under Article 31. Because that was the problem that Angela Mudo found. She sued, and then eventually the court said, but you are no longer an employee. This is about disputes between the community and its employees. Okay, this is Samuel Mohochi. But you see, sometimes the courts make dizzy statements which you think they are high sounding, they look theoretical, but there's a big connection. They're basically saying, you see what I said, that those are minimum standards. It's not even exhaustive. The framers of the treaty were beyond stating the principle and listed, negotiated, and agreed upon a specific minimum requirements that constitute the good governance package. It's clear to us that the provisions of Article 6.2d of the treaty are solemn and serious governance obligations of immediate, constant, and consistent conduct by partner states. In our humble view, we know of no other provisions that embody the sanctity of the integration process that way. Now, one of the things the partner states used to do at the beginning, each time they brought claims under Article 6D and 7.2, was say, those are aspirations. Those are aspirations of partner states. They are no legal obligations. The court shut that down and pointed out from Mohochi, from the Katabas, that these provisions 6D and 7.2 create binding obligations. They are not aspirations. So someone can sue on them. Cepil-Eacj sued on the fact that the partner states had failed to operationalize the extended jurisdiction of the court to hear human rights. And he sued particularly Uganda because they were dilly-dallying. For 2 years, they had not even made the submissions on the protocol. You know now there's a protocol in an advanced stage for extending the jurisdiction of the court to hear trade disputes. Only Uganda hasn't ratified. Only Uganda hasn't signed and ratified the protocol. Tanzania did it late last year. So maybe people should sue Uganda for sitting on your rights. Okay, what I wanted to stress here is that when you see from the book, there is no definition of good governance. Try to find what the definition is. They have used the dictionary, what the canon. Remember your legal methods. Sometimes if you can't find a definition within the ordinary meaning of the word in the legislation, sometimes you have to go outside, find a dictionary meaning. So that's what they do. They use external resources for good governance. Sometimes they use other treaties, like in this case of Rugunda, they used the other African community instruments. In System that Cepil-Eacj, they try to define what good governance is. And sometimes good governance then extends to human rights. You have these cases which have freedom of expression, Museto and others, and other vice Attorney General of the Republic, Burundi journalists. In all these are freedom of expression cases, human rights. And then rule of law also has no definition, but the court said we'll find a definition in the UN. Now, one of the things that will come, these are all rule of law, so they go back to the human rights and all that, all these cases get mentioned. Sometimes the court does an overlap between the two, good governance and the rule of law. Sometimes it finds that, for instance, if you fail to afford someone due process, like in one of the cases, they confiscated the goods in Burundi, and there was a process for which you can confiscate goods under the Customs Management Act, rather than customed goods and all that, and they didn't do that. So the court felt that this was a violation of the rule of law, because there's a law. So the idea of rule of law, that you're bound by the law, you follow the rules. So if you fail to do that, then you have infringed the rule of law. Most of these, if you look at, again, human rights, it also goes to rule of law. Sometimes they merge both principles. Now, one of the things that for rule of law, which you'll find here, which we took time to actually distill, the court has applied a violation of the rule of law and good governance two ways. One, if the law or the action you take in itself infringes good governance and the rule of law, infringes the treaty. So it's the law, the action, the law, especially law and the treaty. So if your action by way of law infringes the treaty by way of it does not accord to rule of law, good governance, human rights, transparency, and all that, the court will find an infringement of Article 6D and 7.2. That's one approach. The other approach is you have a law, say Ugandan law, Immigration Act. Now you do an act that violates your own law. A partner state adopts an act that violates it, even if it's a subsidiary legislation. You might have a law that infringes the Constitution. So your own infringement of your own law as a partner state is an infringement of rule of law under Article 6D and 7.2. So you can find a partner state can come foul of Article 6D and 7.2 those two ways, directly to the treaty itself, or you violate your own law, which is then a violation of. And the court has been consistent. So if you look at all these cases, Grand Lacs, they seize the goods without due process specified in the treaty. So these are now non-compliance with of the partner states' national law with the treaty. Wagari Masakarau, the Supreme Court's decision and right of access violated the treaty. And then, of course, it was upheld. Now, the other one is the non-compliance with your own national law. So in Charimpa, this was the one I was looking for. Construction of Karuma Dam breached Uganda's own procurement regulations. And then that meant that just that alone is a trigger of violating the treaty. Because the idea being that if you're a country that is signed up to rule of law, it means you must also exhibit rule of law nationally. That's what the court is saying. If you are disrespectful of your own law, it means that you are not actually obeying rule of law as an obligation you have signed up on the regional level. This is the one I was telling you, forum. The ministerial ordinance violated the decree. And so the court said non-compliance with national laws amounts to a violation of the principle of rule of law. I like Malek. This is where the Chief Justice of South Sudan fired 16 judges. Now I know, all of you know how they fire a judge here. It's the same approach. You say you write to the president sets up a tribunal will then conduct investigations of it, or incapacity of the judge to perform his judicial duties. And then the tribunal will recommend. So that's the same approach in South Sudan. Under the Judiciary Act, and the Constitution. Now, the Chief Justice, the President fires 16 judges from High Court, Court of Appeal to the Supreme Court. In one go, not that they were fired over time. Yeah? So the court said a decree removing the applicant from office breached not only the Constitution, but also the Judicial Act of 2008 of South Sudan. That means you didn't even follow your own Constitution and judiciary law. So we'll come back to it. I think we'll deal with this in the next slides. Now, I just want to, so one of the things that sometimes you may file is a reference to the court. And then because of the urgency, you feel I need to file for, like we do here in national courts, you immediately file for an injunction or injunctive relief. You file an application for interim measures or some temporary injunction. Especially where the action has not yet been taken, but then you feel that the partner state is likely to do it, and so you file for temporary injunction. Now, one of the things the court has stressed, that if you are relying on 6D and 7.2, they've actually abandoned your approach. What is the usual approach in injunctions? That you must have what, prima facie? They have moved away from that. You must have a triable issue. That triable issue means show us how the conduct of the partner state is likely, when we eventually infringe the treaty. We're not asking you to make the argument, just show us the link. But that is equivalent to your previous case. They have just used the Jumna, abandoned it and said, it's important telling you, show us how. So in arguing for that injunction, you must demonstrate those two elements. Either that the Okay, so the court is saying, show us that we have a triable issue in the sense that, first of all, we have jurisdiction, that you are alleging that an action is a violation of the treaty or a partner state is in violation of its own national law. You must draw those elements out even in your argument for a temporary injunction. But of course, the other two elements pop up. Can this be handled by damages, balance of convenience? And that's actually what was critical in BAT. BAT filed for an application for the excise duty that URA was trying to impose on them to be stayed. And one of the things they argued for damages is that this was going to be damaging for good reputation. And they tried to argue very interesting things. But does anybody know what that case was about? BAT had a factory, like it has everywhere. Factory in Kenya, it was making the same tobacco products. They tried to bring those products on the Uganda market. And they found a different tax excise duty to the goods, the tobacco manufactured in Uganda. If you brought the goods, the tobacco coming from the same company coming from Kenya had a higher excise duty. By the way, we still have those issues. We have a client who came to us and said, I've received this document from the tax authority. No, I don't really say tax authority from Tanzania. They're telling me that if I produce cigarettes with the locally sourced tobacco from Tanzania, this is the excise duty. If I produce cigarettes from within Tanzania, but certain percentage, I think it is like, you need to have 75% of the tobacco locally from Tanzania for you to enjoy the lower rate of excise duty. If the other percentage, the significant percentage comes out from outside of Tanzania, the excise duty is like 3 times. Now, this is a client who has businesses across. He has Tanzania, he has Uganda, he has South Sudan. Now you can understand probably the strategicness of northern Uganda and South Sudan. That's where much of our tobacco is being grown. So he brings some of his tobacco out of Uganda and takes to Tanzania. Now he's likely to pay a higher excise duty. And his argument was that, but then when we looked at it, we told him that unfortunately, we are outside the, you remember those 2 months? He brought to us the thing when the 2 months had elapsed. There's a young South Sudanese lawyer who interests me. Over the past 3 days, we've been on WhatsApp. No, actually, past week, about the Ugandan crisis. He tells me we have clients. He's that kind of person who, even now when I talk to me, one time he sends me a WhatsApp and says, do we know how we can get that Attorney General of the DRC? We have a matter we need to find. I don't know how he gets these clients, but so he was telling me that. So I was telling him that, are you watching the timelines, the 60 days, the 2 months? Because he's telling me, oh, now they want us, they are now hesitant, they're hoping that the government will give them back their trucks. So it's very interesting, but he's always, and he's very good with the same way where they're always together, litigating those South Sudan cases. In fact, the very first case, it was him who filed against South Sudan. So if you find a case there, Santino, what is his other name? He's the one who filed it. South Sudan, I don't know who advises some of these governments. This had been litigated in Anyang Nyong'o. Don't select a representative of the East African Legislative Assembly. But I think these old men in South Sudan, when they realized there's opportunities to make money being legislators in the East African, they decided to say, okay, so and so, so and so. They created the list of 9 and sent to the secretariat that these are the representatives. The young man said, no, this is not the procedure. And he knew young Nyong'o. So even he applied for an interim injunction ex parte. And the court granted him. He said, these people have not been elected. You are supposed to be elected, not selected. Okay, subsequently they corrected that matter. They went back to the drawing board. But you see, sometimes in this politics, what is you saw the circus recently, where if you are in the good books, I remember the DP person, the minister was already in good books of the government. He had just had this agreement, and so it was easier for him to sail as the DP representative as the. So, but you remember how messy it was for NRM. There are already people they want. They are saying this one. So it ceases to be an election anyway. But the reality is that they want an election of sorts. The joke about it is that who's the electoral college? It's the parliament of the country, of the partner state. It becomes the electoral college for purpose of electing those. So he filed and sued the. So that's very critical that you need to identify what the good governance is. So you need to identify that even when you're applying for those interim measures. So gentlemen, can I have the final? I know we're looking at the actors, but I wanted to just do it in litigating. We can switch off that one and put the final slide. That one is on litigating before the East African Court of Justice. I want to just go through them and then we can then have questions. Again, this one I will just run through it quickly because it's what is the substance of this, the litigator's manual. We wanted to do this so that you can have a quick resource. If I want to go to the East African Court of Justice, what do I need to pay attention to? From the time I begin thinking of litigating all the way to taxation. What do I need to? So we've tried to summarize it in a number of pages. We've put a number of templates of what the document should look like. So engaging in the court, I know just the deputy registrar pointed this out. you need to understand the jurisdiction of the court. That's the first thing. Don't just rush. Just imagine you're dealing with a normal matter you're handling domestically here. Do you just immediately say, oh, let's draw a plaintiff? You first appraise yourself of the facts and say, okay, what's the cause of action and how do we go about it? If it's a company matter, then you say, what are we looking at? Are we filing a company cause? Are we filing a suit? So likewise, when you get a matter from an individual, the first thing you need to, will we fall within the jurisdiction of the court in respect of those three aspects? And for the question that was asked this morning, if any one of those aspects is missing, the court has no jurisdiction. So all the three must be there. The court must have the right person before it. So if you file a case against the KCB, Uganda, maybe because your money disappeared from your account, KCB is the wrong party. You don't meet the rational personage test. It would be a non-starter. Rational materia is what's the subject matter. It must be that there's a matter that involves infringement of the treaty, and you're also asking the court to interpret and apply the treaty. Have you filed it within the 26 months, 2 months, 60 days? Is it not a matter that involves, you don't come and say, oh, you know what, my grandfather was employed in the East African community, never got his pay, his pension. And he was fired in 1979. The treaty was not there at that time. So you must meet all those. So each time, sometimes you'll find the court will just pick, if one of those is missing, the court will say they have no jurisdiction. So you must demonstrate that. And we'll come back to the details of those. Actually, those are the next. Who are the responsible actors? Who can you bring a claim against? And there are only 3 entities you can bring a claim against. 3 categories. A partner state, and this means a partner state. Don't bring a claim against Zanzibar as someone brought. Zanzibar is not a partner. That's why it's called the United Republic of Tanzania. It's a mixture of the old Tanganyika and Zanzibar. Someone brought a claim against Zanzibar. The court said, but this is not a partner state. So it has to be a partner state, in which case that means the 7 partner states now. So you can actually bring claims against DRC as well. The Secretary General, on behalf of, in respect of the obligations that he has under Article 29. And then institutions of the community. As I mentioned, those constitutions we listed. So you need to be able to understand that if it's Lake Victoria Basin, if it's the University Council, are these institutions. So you go to Article 9 to identify who are the institutions. So Kenya Ports Authority is not an institution of the community. Someone brought a claim against Kenya Ports Authority. It has to be an institution of the community, not an institution of a partner state. And the institutions are clear. As I said, there's a list of them. And then if there are those which they say the surviving institutions, you need to go back and look at what are the surviving institutions. As I said, the material, look at Article 23.1 and 27.1 closely. The two are often interrelated. They look at them together. Treaty interpretation, treaty infringement, and non-compliance. Article 27.2, extended jurisdiction, that requires protocols. If eventually the protocol on the extended jurisdiction of the court on trade matters comes up, then that means you add that as a subject matter jurisdiction. The court now can handle trade disputes. In future, when human rights protocol comes up, if it eventually passes, there's a zero draft, then you add that. Instead of going through Article 6D and 7.2, you now proceed under the protocol on human rights. So those are the options. Incidentally, in ECOWAS, they had a protocol to extend the jurisdiction to human rights. So now the court handles human rights, the community court of justice. Now, admissibility, this is a terminology which is very fluid. Most times when you fail on one of the rationale, especially those which enable you to be admissible, the matter to be admissible, it's called admissibility, but that distinction has not been very clear. So it's just been swallowed up as jurisdiction. But in a typical sense, they would treat that as admissibility. So in jurisdictions like SADC and COMESA, where you need to exhaust local remedies, the failure to exhaust local remedies means your reference is inadmissible. Because you have not even got to the jurisdiction stage. This is the first test. We admit. But we can't use that much in the ES because we don't have local remedies. And the rationale being that what you are challenging is not the domestic law. You are challenging that you need the court to interpret a particular action of a partner state, whether it infringes the treaty. So your argument is the cause of action is infringement of the treaty. And that is not something a domestic court can handle by way of exhausting local remedies. You can't ask the court to deal with the interpretation of the treaty. The cause of action is what sometimes the court calls the direct effect. You have a direct effect where the treaty is what you rely on as the cause of action. The 2 months rule, we have had a debate about this. There's a discussion. You know, in your domestic setting, you can say the person was what? Is it incapacity? That the limitation does not begin to operate if the person is incapacitated. If the person is in a prison, of course, the argument is even a person in a prison can engage a lawyer. So that's a ridiculous argument of incapacity, but a disability. But the court has refused that. The court has just said, identify for us when the date of the first, when the wrongful act was happened, or you become aware of the wrongful act. Now, usually the debate about this is fine timelines. Someone will say, like in one of the cases, the confiscation of goods in Burundi, they said the timeline started the time we confiscated the goods. The applicants argue, no. The time began to run from the time you notified us of the confiscation of the goods. And that was days later. So if you follow the other one, they had applied like 63 days after that, filed their reference 62, 63 days after. But if it is after they got notice that their goods had been confiscated, they were the borderline of around 58 days. But in the end, the court said the day you became aware. Because how can you know that your goods have been confiscated if you have not been notified? And that was also what happened in the case we were handling. They said the cause of action started from the time the Commission on the Abandoned Properties took over. But we argue that the date can only begin to run from the date they became aware that there was a takeover. And that's when they delivered letters to the tenants of the building. So that those fines, so as someone who's trying to look at this, always try to look at what triggers the cause of action for purposes of your client and when the client became aware of. So that's very important because it might be the difference between your case being thrown out. So you must, and you have to be honest with the client. Sometimes that you brought this matter 4 months later, there's nothing really. We have identified the time when you should have the thing happen, the action happen. When you become aware, it's not good to rush to court to file a matter which will go nowhere. So legal standing. When you file a matter, you must demonstrate you have legal capacity to bring the claim. So you must be a legal or natural person. Article 30. So it can be you and me, or it could be a company, a corporate body. It could even be a partnership, which has the form of existence, a business name. But you must have some form of existence. Now, residence is required. I know the Deputy Registrar pointed this out. Residence is critical. It's a matter that will continue to be discussed, whether this keeps away all the you and me who might be in the diaspora. But what is critical here, and I think which you need to notice for purpose of handling your client, even when your client is out, maybe living in the UK, you can then decide what what's the vehicle for the claim. Do we proceed with you as a natural person, or do we proceed with the investment vehicle, the company which you have used? Especially if the action is against the vehicle. Maybe they have taken over your shares in the company, or the attack is on the company. Because the residence for the company is the place of incorporation. If you are incorporated in Uganda, you have the document, the certificate of incorporation. That's the evidence of residence in East Africa. Now, residence, of course, as the Deputy Registrar pointed out, if you're Chinese or wherever, you meet the test. As long as you're a resident, you have presence in the EAC, any of the EAC partner states. And this is actually critical. Some countries actually make residence and the establishment very important for you to do any trading arrangements. Tanzania recently issued in 2022 its foreign exchange regulations. And they're very critical for purposes of who can trade in shares, who can move money across East Africa. And the understanding will be that if you have been in residence and you have a business establishment in Tanzania for 12 months at least, they know you are here to stay. At least you have been here for a while. Then Muchibi, who decides to go through Tanzania and stay for a week, Muchibi won't be allowed to buy government securities in Tanzania. So there are those critical issues. So you, a resident in Tanzania, can be allowed to move money to buy securities that are listed in Uganda. But to someone who's non-resident, you might find it difficult unless you're East African. So there are those kind of small details which are critical. So residence is important. And I think I can understand where I think the idea was that you want to, if this is a trade investment driven regime or arrangement, integration process, you want as many people to be able to access the court who are investing and trading in East Africa. So that word of they use residents, not citizens. So next time, first thing you need to do when you meet your client comes to you, make sure that he's a resident. It doesn't have to be a Rwandese staying in Rwanda. We have had very interesting. If you look at the book when we do both the litigators, we have instances where the person is an exilee, a Rwandese exilee based in Tanzania. And the court says, yes, you meet the test for residence. Because you are in Tanzania, even though you're bringing your claim against Rwanda. Corporate bodies, legal persons, this could include civic organizations. The East African Law Society led much of the litigation in the early years. You have Legal Brains Trust has had a number of cases there. There are a number of other NGOs and CSOs out of the partner states, some of them specific to media, some specific to civil society. Corporate bodies. As a corporate body, one of the things that you should ask from the body or the company or whatever is, can we have the incorporation documents? Because when you file the reference, you must attach them. You must attach that evidence under Rule 25 of the East African Court of Justice Rules of Procedure. So you must attach that. The locus standing is in the company, not shareholders. Mr. Governor will tell you, we have a case which took close to 10 years before the Cepil-Eacj, with very troublesome interveners. And who were the interveners? The shareholders. Minority shareholders who held 3% of the company. The matter even went on appeal. They said they still want to be heard on appeal. So it's not the shareholders who have the lockers, it's the company itself. I know we have those minority, what is shareholder protection, and when they can file claims, but before the court, you can only come as those, as you said, the interveners that you want, because any decision that is made on behalf of the company might affect your shares. But you can't bring a claim on your own. Claims, there are two different things when you notice. The terminology is different. For claims under Article 30, 20, 28, 29, 30, they are called references. Claims under, suits or what I call them. Matters brought under 28, 29, and 30 are references. Under 31, they are called claims. So your heading will be reference, and then the other one will be claim, where there are disputes between employees. The other applicants, incidentally, the other people who have legal standing are partner states. Unfortunately, we have not had a partner state versus a partner state claim, but partner states can bring claims also against each other. They can also bring claims against the community. Now, the partner states can only bring claims against each other for the fact that the other partner state is failing to fulfill its obligations. An individual can't bring a claim that the partner state is failing to fulfill obligations. That's been the argument in COMESA. The respondent, the only proper respondent, this is what the court has said, to references under Article 30 of the treaty, partner state and EAC institutions. So non-partner states can't be brought a claim. As I told you, Zanzibar is not one of them. The AG is the proper named respondent. So all the cases you'll see is Attorney General of the Republic of Rwanda, Uganda, and so on. The other officers of a partner state cannot be brought a claim against. So don't say, okay, I'll bring a claim against the Attorney General of the Republic of Uganda, but I'm also going to add some officials as respondents. No. All those people, you can only say whatever they did is attributable to the partner state and the Attorney General. You cannot then begin saying, I'm so annoyed with everybody who was involved, so I'm going to list them as respondents. The individual officials, no. The agency instrumentality of a state can also be brought, not to bring a claim. Recently, someone who decided to sue Central Bank of Kenya. And literally, the lawyer tried to sell an argument to the court that the central bank literally does work of financial functions of the government, so it can be sued on this. The court said no. In another case, the person sued KCB. I don't know why that person didn't go to the national court. And that to do with his or her accounts and some money out of government. As I say, the EAC institutions, they must be listed institutions. They cannot be institutions of a partner state. So go for the institutions of the EAC, not partner state institutions. They are not institutions for that purpose. Appearance and representation, all this, by the way, are here in the litigator's manual. You can either be a person or an agent or an advocate. The agent is usually for a company. Duly appointed to act on his or behalf. For the EAC and its institutions, as I said, it's the counsel to to the counsel to the community. Legal person can be represented by a manager or director. So sometimes when you are, just like when you're in the national court, the court will ask whether there's a representative of the respondent when it's a company. And you say, yes, the managing director or the CEO is here in court. We take it for granted, but the idea is that representation, the person, appearance, the person is there. The company can't appear physically, but there must be someone who appears on behalf. I remember during the COVID times when the Cepil-Eacj was hearing its masters online, the advocates would be there, the judges would be in Arusha, and in our case, the client, the majority shareholder, was in Dubai. We were all visible online. Advocate must be entitled to practice in a partner state. Basically, you must hold a recent or valid practicing certificate. Now, the best thing usually to do if you're practicing before the Cepil-Eacj, each year you get your PC, and you know that you're a regular peer litigant or advocate in the court, file the PC with the sub-registry, a copy of the PC with the sub-registry. So they have a record that you are entitled to practice in a partner state. So that nobody raises those issues. We had an embarrassing situation one time where the Attorney General of Rwanda tried to argue that the other co-counsel didn't have a practicing certificate. I know you might think that it usually comes up in national courts where counsel wants to embarrass fellow counsel, but it also sometimes happens in the Cepil-Eacj. So just make sure that if you're practicing before this court on a regular basis, each time you have new PC comes out, just take a copy to the registry. The sub-registry here is supposed to be in the Supreme Court, but since the Supreme Court seems to be in a fluid state of premises, pleadings, again, like another domestic court, the entire litigation before the court is by way of pleadings. Here you file your plaint, you are originating summons and all that. So you must do pleadings. So in pleadings, this can be a reference or a claim. As I said, the reference is the normal 28, 29, 30, then claim is 31. You must present a statement of a reference or statement of claim, and at Rule 25, it details out, just like you remember your CPR, tells you what your plaint should contain. So the statement, the rules provide for what your statement should claim. It requires party names, residence, subject matter, supporting evidence by affidavit, and the reliefs you need. You know those things where you say that wherefore the plaintiff will seek against the defendant the following declarations: the breach of contract, general damages, and costs. So you need to place that. Then if there's an illegality of the respondent, then there must be an affidavit. Remember, this is a reference. Just imagine your petition. So you are not, because in the end, you could either proceed by way of the affidavit, or you could cross-examine on that affidavit if you want. But at the end of the day, the evidence will be based on that affidavit, and that affidavit then will contain supporting documents. If you are claiming, for instance, if you state that the respondent is a company, or the respondent is, then you attach the certificate of incorporation. If you're alleging that there's been a confiscation of the goods, you attach evidence. Maybe there was a letter confiscating the goods. So your affidavit will basically be like your evidence with all those attachments. Of course, there have been debates over the years. What kind of evidence? One time, people wanted to introduce digital evidence, electronic audio evidence. If the evidence, applicant is a corporate body, defense, what is required that there must be an able-bodied defense. Unfortunately, we were unable to get the Attorney General's lawyers in, but I know that most partner states, the defense tried their best. The Attorney General's chambers do their best to provide the spirited defense. Just like you write a WSD, there's a requirement to do a defense, and not a defense of general denials. It's a defense like the way we do. We basically respond to each assertion in the plaint. There's amendment of pleadings. Again, this is detailed out. I didn't go into those details here. Same principles. You can amend the statement of reference and the defense at will without leave of court before the pleading is closed. Now, once the pleading is closed, like for instance, if the defense has been filed, then you can only amend the statement of reference with leave of court. So you'll actually have an application for leave of court. Third parties, the court allows for amicus curiae and interveners. Now, you will receive these decisions. Then you ask yourself, but Dr. Noya said that the proper respondent is the partner state. But why am I seeing Legal Brains Trust versus Paul Muchibi? Now, those happens, or Paul Muchibi versus Legal Brains Trust. Now, those happens when, for instance, Paul Muchibi wants to intervene as amicus curiae. Now, the application must be raised by the person who wants to intervene. In this case, Paul Muchibi. Now, the person who was the applicant in the reference transfers into the respondent side. So if it was Legal Brains Trust versus Attorney General, so it becomes Paul Muchibi versus Legal Brains Trust and another. So when you find those cases, you know you're dealing with amicus interveners. They are not that they are suing non-partner states. So those are yeah.
There was a decision where a Kenyan lady brought a reference. I don't know if it was a reference or she came directly to the Cepil-Eacj regarding a matter, I think, to deal with women's rights, human rights or something. A Kenyan, she told us this morning. Yeah, because you're saying who can bring a case. We're looking at individual persons.
Yeah, individual persons can.
Yeah, they can.
Yeah, they need to be resident. Legal persons. There's natural and legal.
Okay, so I can, like me.
Yeah, you can. Natural persons and legal persons.
Yes, you must sue the state.
You must sue the respondent, which must be either one of the partner states
or institutions of
institutions of the community.
Of the community.
But they must be both a partner state. Don't sue, like in that case, don't sue Zanzibar. Okay, so I think that's probably the end of this. Yeah. But as I said, most of the detailed information all the way to how the court proceeds with hearing, the scheduling, the preliminary objection that Paul Muchibi pointed out, that if I want to raise objections as to jurisdiction, that's done at the scheduling conference. You raise that point so that becomes part of the agreed issues for the court to go ahead. So if that's there, then when the court, the parties are asked to make submissions, or that's the agreed method for proceeding. Sometimes it can be just as we do here, just written submissions and no oral submissions. Then the court can resolve that issue based on the preliminary objection, especially for jurisdictional issues. As you will see from the litigator's manual, the court will prioritize a jurisdictional issue. It's not going to say, oh, let's wait until we hear the merits. If there's an issue about its jurisdiction, the court has to resolve it. After it has resolved the jurisdictional issue, then it can go ahead. Remember, this is not that they are going to say, let's first hear the preliminary objection. Your preliminary objection will be part of your submissions for the entire case. Because you have scheduled the preliminary objection plus every other. Because you say, basically, you know how it is. If you lose the preliminary objection, you must still argue the merits. So now what the court will do in its decision, if the preliminary ruling on jurisdiction is sufficient, it will stop there. If it finds that you brought the claim within the 60 days, the 2 months, even though the Attorney General had argued that as a preliminary objection, you will say all the 3 rational material are met, it will still go then after disposing of that part, then it will go to make a decision on the merits. We need the same decision, same judgment. So don't think that you're going to raise the premium objection and then when it comes to submitting, that's all you write. Your submission will cover both the preliminary ruling, objection plus the merits of the case itself. Yes, can we have, I don't know what, it's coming, it's 4. Can we have quick questions? You can pick T, by the way. You can pick T. And then, as I said, I'll keep looking at what else you need. Because I want, by the time the training is over, it's not just that you have got this basic knowledge, because there's little you can cover in 2 days. There is even much more depth that you could look at if you, I know that the University of Dar es Salaam offers an LLM in East African Community Law. You can imagine that's for all year, so you can imagine what they are covering. They are not just covering the court, they are not just covering good governance and the rule of, they are covering so many things. But I'm hoping that if I can get you the resources, I'm trying to look for if I have the book that was published by the former president of the court, who is now Attorney General of Rwanda. Because it has various edited topics which were edited. Some on competition, on non-tariff barriers, rules of origin, so that you can just acquaint yourself on those things. I'll try to see if I can. I remember I had downloaded it. Interesting read. Much of it is generic because I think that time there is no, like I would say, there is no experience with some of the things they were discussing. So the rules of origin had just been adopted, competition law had just been adopted. So what they're basically doing in most of these is just to provide an understanding of what the principles are. I'm sure if they wrote that book now, 10, 15 years down the road, then we'll probably be looking at what have been the experiences in these laws, in these regulations. Yeah, I'll keep tracking those. So any questions?
Thank you so much, Doctor. Francis Tumwesige is my name. I have 2 issues. One is relating to cross-border practice, I would say. Does, for example, depositing a practicing certificate from Uganda with the court entitle a lawyer to represent a client in matters that arose, let's say, in another partner state, let's Kenya or TZ or whatever?
Before the court?
Yes. Before the ESJ.
Yeah, there's nothing to bar you from that. Your client is come to you for services, for representation before the East African Court of Justice. The East African Court of Justice just requires that you have a PC and be
from somewhere,
from one of the partner states.
Okay, from a partner state.
You must be eligible to practice in a partner state.
Okay, thank you. And then secondly, how is the performance of this court in terms of backlog? You've said you had a case lasting there 10 years. Part of our biggest problem with our courts is backlog. How is it performing?
The court is sort of also backlogged to an extent because it's an ad hoc court, meaning that the judges don't sit permanently in Arusha. There are only 2 people who sit in Arusha, reside in Arusha. That's the judge president of the appellate division and the principal judge of the first instance division. The rest of the judges come back home until there's a session. So when I met Justice Nwabwire Wejuli in an event recently, and I was telling him we were in Arusha and they met the judge president who were busy in a session. He told me, yes, we're also supposed to have a session as the first instance division, but there's no money for them to have that session. So they're hoping that maybe they will have a session in September there. So that affects, because if the court is supposed to do, just imagine, a court is supposed to schedule matters 60 days after the final pleadings are in. We have a matter which the final pleadings were in by end of, I think, mid-2012. 2022. Now it's almost a year since. 360 days instead of 60 days. So you can see, so that creates backlog. But one of the things they try to prioritize are those interim, temporary injunctions, especially the interim. Because the interim, then one judge can hear, so since the principal judge is permanently in Arusha, you can ask the register to have it fixed, and he will hear it. And once your principles are sound, I remember when Justice Monica Mugenyi was the principal judge, what Santino Jada did is argument for interim injunction ex parte. She's the one who granted it. And said, okay, but it's a very interesting direction she gave. She directed that we'll grant the injunction, but in the meantime, go and serve the respondent with the main application for an injunction and the reference. And then they were not going to hear the main they were going to hear the main application inter partes, and they would fix a date. So there are those interesting things that sometimes they may decide not to give the interim injunction and just say, these are our orders, go and serve the respondent, we will hear the main application inter partes. But you see, that's now one judge doing that. But hoping that then when the session comes and there are 5 judges, then they can hear the main. But so that's what probably explains the backlog. And our case wasn't that it was backlogged because those 10 years. The matter was first heard by the First Instance Division. It went to, there were so many applications. The interveners wanted to come in, there were amendments, there was leave to amend. Then when the matter was heard, we appealed to the to the appellate division. The appellate division said that they didn't understand what the trial court and the lawyers were up to. There was no evidence. So they referred the matter back to the First Instance Division for trial de novo, to be tried afresh. When it came back, the Attorney General of Rwanda decided not to begin playing tricks. They first of all began challenging Mr. Gimara's right to represent the applicant. The interveners were also being a nuisance. Then after that decision, the Attorney General, which was in the favor of the applicant, the Attorney General appealed. We cross-appealed. In the midst of that, the Attorney General of Rwanda still files a challenge to Mr. Gimara's right to represent. The interveners also file an application that they want to be heard on appeal. So if you find Union Trade Center among the cases that I've listed, and you see like 6 of them, those are some of them applications, some of the, so there have been, and that's not all, I've actually not included all of them. So that's partly what happened, that by the time the appellate division had the appeal, they didn't give us the remedies we wanted them to direct that the mall be restored, because it was a very expensive mall. But they increased the general damages from $500,000 to $1 million. But also it taught us a lesson that if you're ever going to plead for damages for expropriation of property or taking of property, you need an evaluation of the property. You need to, because they were saying that you didn't lead evidence on the value of the property. So there are those things. So you need, there are lessons, as Mr. Gemara pointed out at the beginning, that everybody was trying to learn as the court went on. And the court has said that they want lawyers to read this manual, their user manual and all that. Because sometimes they spend a lot of time with lawyers just dealing with procedure. The procedure has not been the right one. So sometimes you find the savvy lawyer will say the procedure is wrong, it gets challenged. then you go back, then you appeal. You know, like the way you think we're the ones who appeal only domestic courts. An application is dismissed, you appeal to the Court of Appeal, all the way to the Supreme Court, and then you discover that the substantive dispute has not even been had. So sometimes parties also do that. They appeal all the way to the Court of Appellate Division. By the time when you look down 3-4 years down the road, the substantive difference is not even been had, touched. But one of the things we'll be looking at tomorrow is that how do we drive the backlog away from the court? Can we use the national courts? I know people think national courts, I'm sure probably in Rwanda and in Burundi they would not want to use national courts because they're not sure whether the judges would be. Yeah. Now you can imagine that if we had filed a case before the national court, that our client was tried in absentia, and this is in violation of the Criminal Procedure Code in Rwanda, it's in violation of the good governance rules, and yet the Attorney General's office is denying that there was even a court which issued the sentence in absentia. So how are you going to think that you'll get, so in such a case, it's probably better to go to the regional court. But one of the things that the court has jurisdiction is what is called preliminary rulings references. You can take your matter to the national court, and then if it raises issues of interpretation of the treaty, then you ask the national court, the judge, to refer the matter to the East African Court of Justice for a ruling. That's why it's called preliminary ruling. So you refer to the court to give you a preliminary ruling. Now that ruling which is given, when it comes back, use it to resolve your matter. Just imagine like a constitutional reference. You refer the matter to the constitutional court on an issue of constitutional interpretation. That ruling from the constitutional court, when it comes back, you say, okay, now we're proceeding to resolve this dispute. So that's the parallel of the preliminary ruling. Now, what has happened in the European system is that the European community law has actually been grown, has evolved genetically from the national courts. National companies file matters before the national courts and ask for preliminary rulings. Now, the beauty about it is that once the preliminary ruling comes out, it binds all the partner states. It's authoritative on that interpretation of the treaty. So next time round, you don't need to go back to the court. You just use that decision and say previously, in this previous decision, a preliminary ruling reference was given, a ruling was given, and this is how the community law applies. So we're hoping that we can get, because everybody is filing every matter, Article 6D and 7.2 to the court. I have a feeling that the court must feel this exhausted, that they've seen this before. Why can't these people go to the national court and just say, okay? And when we look at it tomorrow, you'll find the court has set 3 principles. One, is East African community law really relevant to resolve this dispute? These are now the choices for the national court. If the European East African community law is irrelevant, that means this dispute can be resolved primarily by domestic law. Then they don't need to refer to the court, to the regional court. If there's already a previous ruling of the court on the same matter, then don't refer. Just adopt that ruling. So like now, if I was to tell you, if you have a matter which has 6D and 7, why you're trying to rely on that, go to the national court. If you feel the forum is very okay, human rights, freedom of expression, and just say, okay, this, not only does this violate the Constitution or this other section of the law, but also the ESC, Article 6D and 7.2 of the treaty. One of the cases where actually they discussed the preliminary ruling actually was that was the question, is Article 6D and 7.2 justiciable in national courts? And the court said yes. So you can file matters relating to 6D and 7.2 before national courts. Now, the third principle the court pointed out is that if the matter requires them to interpret, then they will handle it. And once they finish they make the preliminary ruling, they refer it back to the national court to proceed to to resolve the matter. Now, one of the critical things, I don't want people to feel discouraged, that if now the court says there is no need for me to refer the matter to them if they have already issued a ruling, because the chances that you might not even know. I don't know how many people know BAT. But what the court has said, if you send to us, the National Court sends to us a request for a preliminary ruling, and we've already made a determination on a similar matter on this principle, we're not going to say no. We'll just get a copy of that decision and attach it to and write a short statement on the preliminary ruling and say attached is our previous decision. Use this to resolve the dispute. So they're not going to throw it out, your request. They'll tell you that we've already handled this. Here is the ruling. I mean, the decision which has a ruling bearing, a decision which has a bearing on what you want us to make a preliminary ruling on. So that's what we wanted us. Tomorrow morning we'll discuss, and then we'll start in the morning with a recap, but we'll also do a sort of, to make you understand the nexus between the national courts and the regional courts. I know everybody wants to go to Arusha, but these days it's not really very important. It's just, I know lawyers used to love to go there. They would do flight, get tickets, burden the clients with the money for hotel. But as the deputy registrar pointed out today, in all the time, there's a time we had to file a matter before 30th of December. We looked at the 60 days and they were expiring on 1st of January. So we called one of the clerk to the Supreme Court registrar, that we need you to be sitting in the registry. We finished the references and all that. I had them in PDF format. We had all the affidavits commissioned. Then we took him to him. They will receive it in a digital form. If you take to them a hard copy, they will still turn it to a digital form, because then they must send it to Arusha, remit to Arusha the digital version. Of course, at the end of the day, they will take copies. Now, one of the things that Justice Kiriabure, when he was in the Court of Appeal, told me that it used to be so annoying. He's going for a session in Arusha from Uganda, and they have given him these files that he has to carry with him. Carry with him to Arusha. Now you can imagine, you can now have all this on your tablet or laptop. You no longer need to carry those things. So now what also the registry is planning to do is that you can even do audiovisual hearing. They are now trying to have the sub-registries accommodate audiovisual hearing of matters. So the days of rushing to Arusha are gone. And that basically means you can actually even hear the matter here in the National Court, ask the judge to make a reference. Of course, the burden is for the judge. We're planning to do 2 trainings for judges specific to this, so that the judges could understand that they have a role. This is their role. It's not actually you as an advocate. But one of the things we're also asking, because there is no procedure, the procedure just says the matter for preliminary ruling can be raised at any stage. You can raise it at the time of filing your claim or suit before the National Court, or you can raise it during the conferencing and all that, and which then the judge will then make a determination whether they should actually refer. Now the question is, what's the format? Do you need to make a formal application? Does the judge, there's no template of what the preliminary ruling request looks like. So we had offered under this to see with the judges whether we can craft one which can then inform the judges of what it should. But there's a detailed procedure, requirement of what it should contain. Yeah. But you see, like, for instance, our constitutional references, the guideline, the regulations, tells you what you need to put in. So we need to probably get something like that, maybe guidelines or a template, what it should look like. So that's what we'll be doing tomorrow. Then we'll have a practical exercise. That will occupy most of the day. Depending on what people think, but in both Rwanda, Kigali, and Kenya, Nairobi, those people who felt that they needed to take time in the afternoon, we have the optional clinic in the afternoon. Normally, I found myself with 6 or so people who just wanted that they have interest, they even have matters that they want to take to the court. We would have sort of like a discussion of what are the implications. And incidentally, we may not have a big budget, not budget for you to like represent the client, but to help you with the logistical aspects, we have, I think, some money for supporting lawyers who might want to litigate before the court or matters that go to the court, indirectly through the national courts. We're still trying to lobby Ford Foundation to give us more money for the next 2024. Because they have seen the implications of us doing this. People are getting to know, and the fact that we're doing these materials, people are getting more well-versed. So I'm hoping that when we give you these materials, don't think that, I know your bread and butter for most law firms is corporate and commercial. But think how you can upgrade that corporate and commercial into the integration space. Your client who is selling goods here in Uganda, talk to that client and say, "Where do you want a bigger market?" Yeah? Your client you might be the person who is as a client. I always tell people jokingly that that the opportunities for your client to expand. It's just that we never tell them. They all think of, and that's the big businesses have figured it out. The hospitality industry. I used to think Onomo Hotel was some Ugandan who had stolen COVID cash and put up a posh hotel during the period of COVID. Onomo Hotel is a South African chain. In fact, Kampala, it's its latest. It's in Kigali, it's in West Africa. 4 Points by Sheraton. It's first appearing here, but it's already in Tanzania, Dar es Salaam, and in Nairobi. Of course, we're all well versed with the Serena. Serena is everywhere. So they have figured out that you can actually expand. I see CJs is also beginning to figure out. I was joking to them that they should next go to Tanzania. KFC is in Rwanda, but there's only one outlet. But then you start somehow. Even in Uganda, we started off with one outlet. But the reality is that you can actually convince your client that the commercial corporate work they're doing here can also be done elsewhere. They can do partnership, they can do synergies. Your client doesn't need to go and establish himself in Kenya. He can create a joint venture, it can create a partnership with another entity elsewhere, in another country, and exploit the opportunities for expansion in those territories. Do the same work that you are doing here. So I want you people to think, so when you are looking at, so that means that you need to understand these instruments. So when you are telling your clients, we go to Nairobi, you need to understand also what is happening, the laws in those countries. Because we're like, for instance, ALP were cross-border firm. We get referrals from Kenya. Kenya one time told us there's this client who does the Cepil-Eacj work, they want to come into Uganda. We do the work now. I met a former professor who told me, I have a lot of money coming into Tanzania from, I called it the LP Tanzania office. They are talking. Yes, Paul.
Thank you, Doctor, for the presentation. One on the issue of backlog he raised, I find the practice of the ESCJ in granting interlocutory orders also getting similar to the domestic jurisdiction, where somebody files a very frivolous case, but merely wants to get an interim. And after getting an interim, because he's aware that the main application and the main suit are going to take years, so he's very comfortable with the what? The interim. Specifically, people, for instance, in land who grab land, go there and get interim to stay there. So if the court issues interims and takes a long time to dispose the main reference, then that also becomes a problem which the domestic court we are getting tired of, and the regional court is doing the same. Secondly, on the issue of backlog he raised, of recent, we see in the annual East African Court of Justice Judges Conference, after the conference, they are having a form of a session in the host country of the conference. Last year it happened in Uganda, and we hosted them at a commercial court. That helps to dispose a number of cases, though I don't know the fate of decisions. But at least hearing them, they quite handled about 30 cases just after the conference. So if that practice continues also somehow, it helps to sort of reduce this kind of backlog. Then the other concern is in respect of this issue of rationale temporis. In our domestic system, for instance, under the civil procedure rules, it is clear that the cause of action arises. I mean, time, if you are computing time, time reckons from the date the cause of action did what? Arose. However, there are clear exceptions that I may not have been aware. So time will reckon from the date I got to be aware. Here under the treaty, it's a bit tricky. It's trying to say when the event occurred or when you got to know the event. That puts you in a fix whereby you are the claimant, you got to know maybe on date X, but the other party is arguing the event occurred on date what? Y. So do we have clear exceptions on this cause of action, or it is plainly like that to start computing time? Then the last I have is on the issue of the human rights protocol. Way back, Stenda Sevalum, that 2010, this matter, and I think even partly Professor Anyang Yong handled that issue of lack of the human rights protocol by the court. And the last time I knew, it was Tanzania and Uganda that had not what? So now from the new information, say Tanzania did.
But Tanzania has done, that's the trade, one extended trade. The
No.
one of human rights, maybe it's the two are still stuck.
Exactly. And you see, the court has already seen this challenge. Matters have been presented before the court. Some partner states have chosen to ratify the protocol. Others are purely silent about it. Yet under the treaty, there is good governance and also human rights, though in those cases, some are trying to hide human rights under good governance. Now the concern is what's the role of the Secretary General now of the, and even then, the partner states that are adamant or hesitant to ratify this what? Protocol. Is it a matter of choice? Doesn't it conflict with the treaty? And how are we going to properly enforce human rights without this protocol in place? Is it something we are going to leave until some partner states feel like they are now okay to do it? Because this is, since 2010, this matter has been pending in court of the protocol. And there is, I've seen a draft protocol. I don't know whether the one I saw is the one which is still there, but it was crafted some time, but it is not being operationalized because of some partner states. So are we going to leave the situation like that forever? Or this is something we can take on as maybe law umbrellas, bar associations of partner states, or led by the East African Law Society, to go back to court and demand, why don't we operationalize the protocol on enforcement of human rights? That's my take.
Yes, to start with the protocol, as we said, sit and legislate had this before the court. One of the things that there are two options here. can we go back to the court to basically say that the non-compliance with decisions of the court is a violation of good governance or rule of law? Because I know that's the argument which the Zimbabwean white settlers did, that there was a judgment issued by the SADC tribunal. Zimbabwe government has refused to adhere to it or observe it, and they went back to court to have a pronouncement to that effect. Now, the other thing is probably, which I don't know whether it's something we have the power to do, how do we, can the other partner states which have ratified take those who have not ratified to the court for the first time that we have a partner state reference? Because I know it's always the idea that what's the scripture that don't point at what a speck in someone's eye when you so maybe the partner states don't want to begin ruffling their feathers, each other's feathers. But that could be an option, that these partner states are holding up as things which are good for integration. And well, it's an option that can be explored, and because that one would be something probably the court would be interested in, seeing that partner states which have ratified are saying you people are holding up. So there's that option. Of course, for now, we can continue just litigating human rights through the good governance route. There's nothing stopping us from doing that. Of course, it is a bit of a stretch. Sometimes you want to argue the essence of human rights in their original form, rather than trying to sort of camouflage or close it as good governance. For the backlog, as you said, the effort of the court to have a session in a partner state, which they have been doing, I think, for the past 3-4 years. They did the Bujumbura. I think Kampala was next. This year they're doing in Kigali. Now, because what they're trying to do is to say that, first of all, take the court nearer to the partner states, to the nationals, for them to see the court, rather than the court being so distant in Arusha. But it also helps them to then hear matters. The good thing also these days, the matters are either the matters for that partner state are involved, or even now they can be online for the other partner states. But as you said, they list several cases. It's probably part of the usual session, but it's just taking it to another partner state. Now, I can tell you that the court has actually been very vigilant. Each time they hold a session, before the next session comes up, they have issued judgments. So for the purpose of these two books, we waited until February. We knew we had got a notification that judgments would come out at the end of February. So we waited to see if there would be new judgments on good governance. We even waited for the arbitration rulings so that we could include them both in the source book and the litigator's manual. But unfortunately, there wasn't much that affected good governance, and then the arbitration rulings were told the parties decided that they should be kept private. So in the litigator's manual, we point out the names of those cases, but we couldn't get. We don't have any. We don't have any hyperlink to the to the rulings, because that's what happened. But if you go through this manual and the source book, you will find that it's up to date up to 2023 February or December, November 28th of 2022. Because that's when they issued, I think, part of that process of that session in Kampala involved issuing a number of judgments. So if you go through, if you are actually attentive, you'll notice that in 2022, the judgments, I think, in April or March. Then there's one in August, then there's one in November. So I think they've been trying to, that each time they hear, they're not going to wait for the matters to issue the judgments 2-3 years down the road. They have to make sure that the judgments are issued at the next session, the ones which are completed, and especially those ones which were heard in the previous judgment. Because sometimes in one of the sessions they might be scheduling. So once now they schedule, and then they can determine what happens at the next session. Do they have oral submissions, or sort of back and forth on the subject matter, and then eventually schedule? So they have actually been vigilant, but still, even as you know, like our courts, even as you are trying to have courts here matters, how many more matters are being filed? In Kenya was so shocked when I was told that they literally file close to between 200 to 300 cases on a daily in Nairobi alone. And this was notwithstanding their 22,000 lawyers. For me, it looked big. But it's a bigger country, bigger economy. So 22,000 lawyers might look big to our about how many? How many are we, like 5,000, 6,000? But they have now what were the other questions? There was the one of the ratio temporary. No, I think what they've said is that if the applicant we can convince them on the date the applicant became aware of the violation or the infringement, they will go with that. Because sometimes the event and the awareness might be something even. Like for instance, in Rugumba's case, one of those cases, if you are arrested, Paul Muchib, you can't begin saying that you are not aware when you are arrested. it's the event that marks the infringement. You can't say, oh no, I was asleep. And I woke up after a very long rest a week later and discovered had been arrested. No. I think the event is when something that is, but I think because they added the awareness in the sense that the event might happen, but you are not informed or become aware of it until a much later date. So the awareness is also a test, but we've been trying to argue that can't there be exceptions like the incapacity, disability? Like for instance, in Rugumba's case, if it was not the sister to bring the claim, he wouldn't have managed to bring it himself. He was incommunicado, he was in a jail. Now, of course, because of the suit, he was eventually released by the Rwanda government. So, but you can see those are the implications that if the sister, it would have been interesting to see in that case what the court would have said. But the sister was vigilant in actually getting the matter before court. I'm trying to think of another case where the person waited and waited and waited, hoping for something. But the court said, but you were aware. It's just you, I think, was waiting for legal aid, waiting for a lawyer to... Yeah. Then there was the fourth one. What was the fourth one? We have done we have done the protocol, we have done the ratio temporis and case backlog. Oh, the interim orders. Actually, surprisingly, in recent years, over the past 3-4 years, the court has adopted a different approach. Because, as I told you, in Santino, Justice Mugenyi gave the interim, but then directed them to go and what? And serve the respondent the main application, and also directed that the registry fix a date for its hearing. In some, the court has refused to hear the interim and said, you go and serve the parties, the respondent, the main application, and we'll hear the main application. And what has often happened is that even when they hear the main application, they must make sure that the main reference is fixed within the next 6 or 1 year. And what has happened is that sometimes you might get the interim, they get the main application and still lose the reference. I've been tracking them because sometimes I notice that I'm looking at the references, I'm looking at this, so I've sort of tracked them. One of the things I'm also doing, because I noticed that we're providing you with this, but what we're also trying to create is a database. The court has reports with sort of subject matter index, but we're trying to see if we could create a subject matter index that is web-based. So that, just imagine your traditional law reports. So that you know that I'm looking at the East African Community law, I'm looking at the institutions, I'm looking at the organs, I'm looking at the third parties, amicus curiae, interveners, and I have all these cases with the subject matter like almost indexed, so that you can click where it's linked to the case and you read the case. But you have a simplified, sort of like, instead of you looking for all these cases and wondering what they're about. So that's what we're trying to also to do. And I don't know. I seem to have so many things I'm doing. Incidentally, apart from doing the trainings, I don't know how many of you noticed that in the past, the other week I was in the ADR space, presenting the ADR policy and the ADR. But me, I'm more interested in the knowledge component. So we're hoping that we can get those done. And because I have a feeling that the best way for you to encourage you to take interest in ESC law, ESC integration and all that is to make sure that you have the resources that you can easily access. Because it's sometimes so discouraging. I go to ULI. I keep telling people that ULI is not really very satisfactory. I know they have tried to have those things where you can have those, sort of, it can give you, whether you are looking for laws, whether you are looking for judgments, you can even have judges. But I still believe, if you remember our traditional aspect, you go to the index of the book, you look for a subject matter index, you run down civil procedure, then you say, okay, which are the cases, then you go and look at those pages. It's quite difficult. I know, for me, it just sounds a bit difficult. So I'm trying to see if we could do something, especially for areas that I believe lawyers can be interested in. I'm targeting the ESC, we're targeting arbitration, and the ADR. I mean, ADR is part of arbitration anyway. So if we can start with those, then we can see how to interest people to see. Because it's as I said, you go and look at the instruments that we have provided, and I have a feeling all of you will take an interest in ESC integration law. One day you'll come and tell me after 3-4 years that I even stopped doing trespass to land. If you are doing IP, you say now I'm doing IP from the perspective of integration. How are my clients' trademarks protected in the region and the continental frameworks? Because all these things, competition law and the IP, is going to become critical both in the African continental free trade area. You're moving your goods to another country. How is your trademark protected? How is your name, what are they called? The trade name and all that. So they are very critical issues. There's some things you're looking at banking. You'll tell me I no longer do mortgages. I do cross-border banking. I don't no longer do dissolve liquidating Ugandan companies. I'm now doing cross-border insolvency. Think that whatever you're doing now, you can do it on a regional scale basis, a continental basis. And that's what I want. I want by the time you do this, I know all of you went through law school, I thought some of you have succeeded, but I want now you to move to another level. Yeah. So think about it. It's an interesting area. For us at the LP and what I do, we try to keep creating more resources. We have promised that our scan that we launched today will have it on our website, so you can go and read. You'll get surprised what you didn't know. What's happening in the national spaces. So if you have a client who is bringing goods from another country, when you are dealing with, do people have importers as clients, people who import things? Yeah, so now begin thinking what is happening in the region. What opportunities are there? If the client is importing raw materials for their industry, what are the duty remission opportunities? Apply to the ESC for a reduced duty or a remission of duty on those raw materials. Demonstrate that those materials are critical for the development of an economy. Your client will be happy if he has to pay the reduced or no duties on those raw materials. But you must apply for them. Now that's where the Kenyans, Tanzanians, and Rwandese have figured it out. Their lawyers apply for those duty remissions. I've barely seen any Ugandan company applying. So it means you have to go and look at the duty remission rules, look at the format of the application. The good thing, the application has a format. Tell your client that you are doing raw materials in this sector, tell the client, let me look at what opportunities are there for you too. Okay, so any other questions? If not, I want to just to share with you I'm going to circulate the practical exercise so that tomorrow you can go with it. Then tomorrow it will be part of our discussion. Don't get shocked if it looks familiar. Okay, so tomorrow we are starting at 9, so come early by 8:30. So and if you are living out of town, leave early. This city can get clogged by 8. So you might find yourself struggling to get from Kitugum House to here in 2 hours. So just leave. So we'll start at 9. We'll do, as I said, we'll start with a recap briefly of what we've covered today. If there are any final questions, then we'll do a quick review of the nexus between the national courts and the regional court by way of the preliminary ruling reference. And then you'll be divided into groups and handle the practical exercise. Senior Counsel Francis Gimalo will handle much of that part of the segment of the training. And we'll be issuing certificates by midday, 12:30. But as I said, for me, after lunch tomorrow, I'll stay around for anybody who wants to join in a quick take on what they are doing. There's no need to rush away, but it's optional. If you feel that you have a client who has been calling you during the 2 days and you need to rush away. But as I said, this is a discussion we can continue to engage in. So just share the practical exercise. You just hand them over to them. I said if the problem looks familiar, it's because I wanted it to be something that is almost something that you can look at and say, well, this is now a hard problem. Yeah, but realistic to what is happening, what the situation, what would often happen, especially when you have trade wars or disputes over movement of goods. I hope there are enough copies. But this is not new to you. You did this in the undergraduate and LDC. You didn't get? Yes.
Thank you, Doctor. I have a question. I want to pick your mind. You taught us about the directives, and then you talked about more of domesticating them into national laws. Is that relevant? Isn't that duplication? Because if you say that the East African laws or the treaty can apply directly, and then you mentioned that we can actually litigate on the treaty directly. I think you will delve deeper into that tomorrow. Why then do partner states need to formulate laws to reiterate what the directives are saying? Can't the national courts, and they mandated to implement the directives as part of the treaties or as part of the community laws? That's one. Then the other is that direct applicability. I'm a bit confused when you say to go to the ESCJ, you have to demonstrate that you have exhausted the remedy at home, which would be the, did I get that right? Or you can go directly to the ESCJ without going first to the national courts.
You are claiming the treaty.
Yes.
Your reference.
Yes.
The treaty itself. It's no longer domestic law.
Ah, okay. Because for me, I think you were encouraging us to go to the national courts for enforcement of the East African laws. But don't you think it's better that these laws and any aspects of the East African laws are handled by the ESCJ? Because the ESCJ is comprised of nationals of the different partner states. So they come in with varied knowledge. Basically, the input would be much higher than that of the national courts. Because why are we then now burdening the national courts much more? I would give an example. For example, in the national framework, we're trying to specialize courts. You have the land division, you have the commercial division to enhance effectiveness. Now, why would you want to bring the matters of East African Community enforcement and then bundle them up onto the national courts? Wouldn't it be better if they stayed in a specialty court and concentration is done there, capacity building is done there? Wouldn't it be more effective? I don't know, I want to pick your mind on that.
Okay. Yes, you could probably say that. So just to clarify, the reason why you have no exhaustion of local remedies, and the court has stressed that several times, is because the essence of a claim before the court is how they act, the directive, regulation, legislation, etc. of a partner state impacts on the treaty itself. So the court handles a different sphere of what it's supposed to. And that's the same thing with the preliminary ruling. The preliminary ruling is basically asking the court, give us a preliminary ruling on the interpretation of the treaty. Then we'll take it up from there to apply it domestically. Because the argument is that, for instance, if you have a matter where the dispute involves actually the domestic law, but you're saying that law infringes the treaty. So all that you're asking is, how does this law infringe the treaty? Now, if we get a preliminary ruling on how that law infringes the treaty, then we can apply it to as a domestic court, discussing both the infringement of the domestic law as well as the treaty. And the idea being that's how we grow the treaty law, community law generate at a national level. It evolves, and over time, instead of partner states clogging the regional court, the individuals clogging the regional court, what will happen is that your dispute that you take to the commercial division, all that you are doing is that you have another layer of the cause of action. You have added the layer that whatever has happened also infringes community law. So it's not like you're filing a different case. You are just piggy-banking the community law onto what would ordinarily be a national claim. Because the idea being that you want the community law to have a homegrown setting. No, there will be no backlog. No, there's no backlog. Like, for instance, let's take the example of the Vinci Coffee. You could go and say we're challenging the agreement. It violates it offends the whole provisions that it creates tax amnesties, it creates discrimination on the basis of tax between this entity and the rest of the Ugandans. It creates anti-competitive behavior. It creates a cartel where it's the only one which can collect the green beans and all that. But then at the end of the day, you say, okay, this at the same time also infringes its anti-competitive behavior under East African community. You are not creating a new suit. Yeah, that's the assumption, but you're clogging up the regional court. No, that's why you see, now you are attacked as the lawyer, is to say, how do you position your argument that especially when there's an interpretation of the East African community, your argument is to position this argument that the ESC elements of the claim need to be interpreted by the court. So that's why the preliminary ruling reference is. But as you are right, the courts are not very effective. Both national and regional will not be very effective. During that case of the one which had the first case stated, Now I'm forgetting, but we'll discuss it tomorrow. Justice Kiriabwire said the matter came to them because it goes to the Court of Appellate Division. They made the ruling, the ruling. By the time it went back to the High Court here in Uganda, nobody had told them what happened. Maybe the parties had abandoned the case, nobody had taken interest in the case. So nobody told them how eventually their ruling was applied. So, but I'm hoping that if we can get more preliminary ruling matters out, then the national courts will realize that they need to watch out when the ruling comes back, because the ruling must be applied to resolve the domestic matter. So once that begins to evolve, like for instance, I can tell you in testimony motors, Justice, as he was then, Justice Mandrama, was faced with that same problem. He was dilly-dallying in saying, but this requires interpretation of the East African Community. This is not within my mandate. Then he refused to hear the matter. A year later, the same parties brought the same matter, but in a different argument. And eventually he said, oh, now I understand. You don't want me to interpret, you want me to apply the East African Customs Management Act. So he applies it and says Uganda's law is in violation. The approach that the taxation approach that the Commissioner for Customs had adopted for imported second-hand cars was wrong. Now, when it went to Court of Appeal, both parties are not actually relying on the East African Community Treaty, but the Act, the Customs Management Act of the community. And in the end, what was strong in Justice Bamgemere's decision in the Court of Appeal was that that act takes precedence over the laws and approaches adopted by the Commissioner for Tax. So, but you see, that's generic. So at some point, you don't even need to refer to the treaty. Because in that case, the treaty was not actually essential to resolving it. It was an act of the community. So you might say, even for him, he could have just said, but remember, I will give you those, in the folder, you'll find both cases. You read it and you wonder, he seemed to be at a loss what to do. He refers to the community treaty, he says this about interpretation. If I give this interpretation, would it result to conflict, different opinions across East African courts? So I can understand what worry, but you see, if you had said, and the parties, the lawyers are those who understood what it meant, they could have said, okay, let's refer it to the East African Court of Justice. We get a conclusive interpretation on this matter. And I'm sure if they had referred to it, they would have done. Now, the other better example is Anyang' Nyong'o. Anyang' Nyong'o said, if you don't conduct an election in accordance with Article 50, electing members of the Legislative Assembly, not selecting, electing. Now, in 2011, the late Honorable Jacob Olanya sought to stand as an independent. The election process took place, it only concentrated on the parties. So I think NRM got 6 of the seats and FDC got 3. So he said, but if you look at the act, it says take into account party affiliation and other shades of political opinion. He didn't go to the Arusha court, he went to the Constitutional Court. Justice Mpagba Igenes, guided by the council, referred to Anyang' Nyong'o and applied Anyang' Nyong'o. They could have said, okay, let's refer the matter back to the ESCJ. Now, it would have been interesting if they had done a preliminary ruling. The ESCJ would have said, but we have Anyang' Nyong'o, apply it. But because these are like hindsight, we never see the jurisprudence, the implications. But that, for me, was actually the judges saying, even if they had been asked, they would have said, there's no need to refer. We have Anyang' Nyong'o, we'll apply it. And that's what they did. They basically extended the Anyang' Nyong'o, because Anyang' Nyong'o was specific that there should be an election. So for them, they said that the election means include every political party and other shades of opinion. That's what Article 50 provides. Yeah. Yes.
Actually, Doctor, I just wanted to qualify what you're saying. You mentioned it. For example, we have a lot of jurisprudence from the Commercial Court on the East African Customs Management Act, actually regarding, for example, cross-border movement of goods from one border, especially questions on should I apply a single, what do they call it, a single duty, single what? Yeah, a single tariff, or in case multiple tariffs were applied instead of a single tariff, and the commercial court has to determine that decision. You find that we have a lot of jurisprudence these days that on any matter regarding the act, you don't need to have a reference because there is a wealth of jurisprudence regarding both the act and the rules or regulations they are under.
And if actually when you pick I can't remember or look for which judgment, where the court has actually that most of those customs-related disputes should actually be resolved by national courts. That the court has already stressed. That those kind of disputes, let the national courts handle them. Because they might even have nothing to do with the interpretation of the treaty. You just have to apply the Customs Management Act. Which court? No, I don't think it will be redundant.
Me, I think the Cepil-Eacj should handle complex, what we call novel questions. Novel questions of law regarding the treaty.
And that's what the preliminary reference
novel questions, yeah.
That's what the preliminary
that are new and these courts can't handle.
Just look at the variation of it is, okay, it's probably not as good as the constitutional references. But the original idea of constitutional reference that you wanted a court that is unique to interpret constitution. So this is a court which is unique to handle issues of interpretation. As Anne is saying, probably we even look at what are the critical issues and to sort of manage, to create that uniform interpretation of the treaty across the East African partner states. Because each time it issues a preliminary ruling, it applies across. Because that's, I think, when they first amended the article, they added the number of articles, amended the Article 20, I think 3. That was the worry, that the partner states were trying to sort of hamstring the court and move everything to the national courts. But the court said, no, we still have the primary interpretation role. Someone has asked a question about binding nature. Yes, as we said, if you go back to the treaty plus everything else, East African community law, which includes decision of the court, have precedence over national law. And that's why I don't know whether I've included that recent testimony Motors ruling from the decision from the Court of Appeal. I think it was early this year. I'll look for it. And what the judge said, the East African Community Customs Management Act takes precedence of the municipal law in Uganda. So once it is provided for evaluation method for tax, for imported vehicles, that's the method the Commissioner for Customs needed to adapt. Go down, there are about, according to what they were, if you look at it, there is a scale of about 8 methods. So you start with the first. But the commissioner had gone to the last. He said, no. That method, that evaluation method is systematic. You look at the first one, if it doesn't apply, you go down. You don't go to the very tail end and apply that one. Yes.
Where Justice Madrama was handling the matter, and he was not keen on actually adjudicating this matter. You mentioned that he kept pushing it aside, which wouldn't be of surprise, because these are not matters that they have been used to on a day-to-day. This is not something that we were trained in way back from the grassroots. So the community is now here, and then you are dumping this onto them. Yes, I appreciate you're doing that training and the awareness, but what's the appetite like in the partner states in respect to the bench, the judiciary? Are they really keen on adjudicating these regional matters, or they would rather the ESCJ actually handles and you are forcing this down their throats? And then how effective are they going to be if they are going to be handling matters that they're not keen on handling, yet there are lots of other matters that they would rather handle?
No, I think what we need to understand is that the matter which you file before the National Court will probably not likely to be just primarily ESC. For instance, some of these disputes about customs duties, now that one is a straightforward Customs Management Act. So that one, the law you'll be applying is that. Now, if, for instance, in the process, you discover that there's actually a matter of interpretation that might go beyond the Customs Management Act, then that's something you need to refer. Now, I think what you are saying is that the judges are probably not that well conversant. That's not anybody's fault. By 2012, I think the treaty had been in place for barely 10 years. Nobody was probably, as you said, nobody was training on this, nobody was conversed. So for his station is understandable. He was surprisingly was cautious that if he made a ruling, it might result to contradicting rulings on the same subject matter, because this is a Customs Management Act supposed to regulate every evaluation of goods coming into the territory. So if he makes a ruling and another judge in Tanzania gives a different ruling, what would happen? So that's why he was saying that maybe this is something for another forum, until they explain to him in a subsequent application that this is just asking to apply that Customs Management Act. You look at the two decisions and you can make a decision on yourself. You can make up your mind, but you know Justice Mandram, he writes two lengthy things, so you can look at it. But also, I want us to bear in mind that by the time you take this matter to court, you're taking it largely, primarily probably the biggest cause of action will be your traditional causes of action. The ones which you are used to, it will be a plaint, it will be unoriginating or whatever. Now, in there, you have basically said there's an additional violation, there's an additional infringement. This action is, like for instance, just look at Masiang's case. He could have just gone and said, our dismissal. He could have just gone to a South Sudan case and said, you have dismissed us, but this is a violation of the Constitution. And on top of that, you have violated the Judicial Act, which sets out how we are supposed to be dismissed as judges. And the National Court would have made a ruling. But you could then say, in addition to this was a violation of the principles of rule of law and good governance under the treaty. Now, the court would then say, okay, do we need to refer? But then the court said, but we have already had so many rulings on this issue that when you violate your own national law, it's a violation of rule of law. So we'll just apply those principles and apply the case law. So you might find at that point, Masiang would probably, if the courts in South Sudan were working very well, he would no need to go to the regional court. So I'm just trying to tell you that they could have this as an addition. And in that case, if only when it becomes so critical and you want to create that consistent jurisprudence that now you refer. And as I think, until the judges, guided by the advocates, the bar, understand that they can actually hear these matters, if need be, make preliminary rulings, they will never do so. So we have to force it on them that they need to understand that there's this part, they can get guidance and assistance from the regional court, which will give a ruling, then the ruling will be used to dispose of a matter before the court. I think once they understand, also when they understand that, they will know that they must wait for that ruling, and once that ruling comes, they must use it to dispose of. Right now, apart from that singular case, there's never been another case stated. Okay, so I think maybe let's close today. It's already 5:30 almost. We will then continue to pick it up from here tomorrow. You have all the question, so you look at it.
Can we divide them in groups now so that they can work through this as we close?
So how many groups?
In the morning, not now, but it's better you know your group so that we don't. We need 4 groups, so I'm going to, know your group, and then you can chat through this, because this is the problem that we are going to discuss tomorrow. But importantly, it is going to answer most of the questions you're asking now. What should be the role of the national court versus the regional mechanism? When should you, as an advocate, prefer to file here instead of filing in Arusha? And what should the procedure be? And then importantly, what are the details of the things that you need to know when engaging the preliminary mechanism regime under the treaty? So there are 4 questions. There's going to be Group A, Group B, Group C. So we will start Group A, B, C, your Group C, D. So we start again, A, B, C, D. So if you are in A, you are in Group A. B, Group B, C, Group C. So that you go through the problems and you will respond in accordance with the problem as laid out. So we start. No. We'll do the same thing. A, B, C. A. Okay. Let's start again here. A, B, C, D. A, B, C, D. A. We start here. B, C, D. Then A, B. Please say it so you'll remember. D. A, D, B, C. So the A's you can go there now so you know your members, and B here, then C here and D here, so that you know your members and just discuss how you will engage with the problem, so that when we meet tomorrow, we don't waste time, so that we can go straight to the discussion. You'll choose who will present tomorrow, but A answers A, B answers B, C will respond to C, and D at the end of the problem. Okay, have a lovely evening. We catch up tomorrow morning.
Kind reminder, tomorrow at 9, we are starting at 9. Kindly come early, and we'll be closing much earlier than today. Thank you.